My lord,
Yes.
I beg to mention item number 13, my lord, on behalf of N. Soikia, my lord. She is not well. She has already taken consent from the other side, my lord. The matter may be listed after vacation, my lord.
P. Goswami. You are?
Or N. Soikia, my lord. I'm not in this case. I'm S.B. Chaudhary.
MS S.B. Chaudhary, learned counsel, appearing on behalf of MS N. Saikia, learned counsel, representative submits that Mrs. MS N. Saikia, learned counsel, is unwell. Therefore, she prays that letter may be adjourned for 3 weeks. Praise the Lord. List the matter after 3 weeks.
Yes, Your Lordship, my lord, item number 8, my lord. Supposed
Yes.
to file an affidavit, my lord, to bring out record the instruction. My lord, I was for 25 days, my lord, out of station. Then I could not file it. 10 days time may be granted, my lord. Yes.
We'll close it. There's nothing.
That is, my lord, that has been.
You are agreed by proposed inquiry or the summon.
Yes, that has been. They have been found.
There's nothing
not
against you.
guilty.
Therefore, we'll say any summon and all that thing should be.
It can be disposed of on the basis of
On the basis of the
The
written.
only thing that, my lord, I have some difficulty today. I may not be available. My presence may be recorded.
Yes, yes.
We'll then in that case we'll just dispose of on 2 lines disposal on instruction.
Monday,
Well,
on the basis of instruction, my lord.
Item 8
8.
dispose.
I beg to mention-
We'll set aside all the summons
Yes,
whatever
yes,
is
yes.
there.
Yes, yes.
I beg to mention item number 5, my lord.
Yes.
It is regarding the pension matter, my lord. But I heard the pension is receiving nowadays, my lord. But instruction is required. my
Item.
lord. 5.
Yes.
Regarding the pension matter, my lord.
Yes.
Probably he is receiving pension, my lord. 2015 matter. Probably he is receiving pension, my lord.
You will close it.
But I have not received.
No. 2015. method.
Yes, ma'am.
You call up over the phone.
I have no communication system.
Contact him over the phone. We'll close it. We'll close it.
Yes, sir.
We'll close the matter
Yes, sir.
and it become in process. Yes. Heard, Mr.
BBC na.
BBC. Item 5.
Yes.
A BPC learned counsel for the petitioner submits that the relief sought by the petitioner has already been redressed. Therefore, matter has become in process. In view of the above. No, accordingly, no. Having considered the submissions of the learned counsel for the petitioner, writ petition stands closed
Yes.
as in process.
May I please, Your Lordship? I beg to mention item number 9 of today's list, my lord.
9.
9. I'm for the petitioner, my lord. I have taken consent from respondent, my lord. Actually, Mr. Maisina, Mr. Amnat, he's
What is the matter?
fever today, my lord. He's not keeping well today, my lord. Can we have next Tuesday, my lord?
Since that day, since last for 3 months.
Not 2 days, my lord. Last 2 days, my lord.
No. This is 2017 matter.
My lord, in month Tuesday, my lord, he's having fever. He did not came to court, my lord. Tuesday or Thursday, my lord.
In that case, after 4 weeks,
Yes, please.
on the prayer of learned counsel for the petitioner, Mr. Amnat.
No, I'm Mr.
Yeah.
A. Bhattacharya.
Your name is
A. Bhattacharya.
Mr. A. Bhattacharya, learned counsel for the petitioner submits that Mr. Amnat, senior counsel, who is leading in
Senior
this
counsel, my
matter,
lord.
is unwell. Therefore, he prays for listing of the matter after 4 weeks.
Oh,
Prayer is allowed, list the matter after 4 weeks.
hello.
May I please, my lord? I beg to mention item number 10, my lord.
Yes.
Yesterday I have filed my lord adjourned petition.
On the prayer of Miss, but then it's 2017 matter.
Yes, my lord.
What is the matter?
Matter appointment of the petitioner, my lord, in grade 3 post at IIT, my lord.
IIT.
Yes, my lord.
So,
Yes, my lord, get highest mark, my lord. But my lord, private respondent was appointed.
yes.
It is the matter, my lord. My
Yes.
My lord, there is a roster issue that he was the
But
SC
the
candidate.
advertisement doesn't say
Yes,
my
Whether
lord,
this the post is
That is-
reserved or not.
let me, my lord, let me put it this way, my lord. Even though there is advertisement may not have mentioned, but a person cannot be appointed against a reserved category post, my lord.
Why you have
Because,
not mentioned the advertisement?
my lord, that does not create any
Otherwise, he
right
would
in his
not have
favor, my
applied.
lord. That
Otherwise, he would not have applied.
yes,
Who
my
is
lord.
the-
I
who
have
is the
not
authority?
called for interview also.
Who is you are the authority.
I am for the IIT, my lord. That doesn't create any right in his favor. In case of an omission
No,
on my
person,
part,
you don't stipulate, you don't prescribe that.
even though, my lord, the
reserve
law is
in the-
this, my lord is aware of this fact, my lord. Ki, even though selected candidates have no right to be
Forget about
appointed,
it.
my lord.
Will distinguish it.
My lord, on
allow
that case, my lord,
allow the writ petition.
but today, my lord, we are not having any. The prayer was that we listed it.
At 2 o'clock.
My lord, let it be listed after the vacation because the council language is not
Next
there, my
week,
lord.
next week.
Next week,
My lord, the council language is
You
not
are
there, my
working.
lord. My lord, I am.
next week, my lord.
My lord, the council language is not there, my lord. He has some personal difficulty, my lord. That is, and my learned friend had accepted that. He said that.
No,
that
you have said, so you have, you are well aware of the law.
My lord,
You realize that law.
My lord, that
Even if
my
a
lord,
person
I'm
is
not saying that.
selected, he has no right to be appointed.
My lord,
You
without
realize
his,
that law?
without his presence, my lord, I cannot argue the matter. My lord, I am not there in the case.
You
That
are
is my-
conversant with the
My
facts.
lord, I'm conversant. I've gone through the
and
file in the last.
equally conversant with
My
the
lord, let
law.
it be after vacation, my lord. 1
Next
2
week,
days
next
here.
week,
next
My lord,
week,
let it be after vacation, my lord. I'm just praying for this. Because otherwise, my lord, I would have.
How can you have, how could have you hide in the advertisement?
My lord,
You have not said that it's a reserve post in the advertisement.
Actually, what happened, my lord?
my lord,
I
there
have
are.
given
My
for
lord,
my
it is.
lord.
Because my lord, file is also not there with me. My lord, there are certain things.
That's
which,
why
my lord,
next week.
My lord, let it be on the after vacation. My lord, that gentleman has to. He has some personal difficulty. He had a.
You said you are appearing
No,
for
because
IIT.
I without his
Who
presence.
is the appointing authority?
Senior,
My lord, here the authority is IIT Guwahati, my lord, who is
Yes.
the the appointing authority.
You
in
are
this.
appearing, you are standing counsel or you are the counsel for IIT.
I am counsel for the IIT, but my name is not there in the matter. my lord.
Will direct the registry to reflect your name. You can take the second file also next week.
My lord, can it be one small prayer? My lord, can it be on the January, my lord? That is a small prayer I am making because, my lord,
See, you have issued an advertisement without specifying that whether the post is reserved or not. How the people will know? The candidate will know that
my lord, that
had he known, he would not have applied if it's a reserved post.
what I am submitting just, my lord, that let it be after the vacation, my lord. That then I will be also be able because this is I have
No.
just gone through the initial parts in the morning, my lord.
Sir, let me have the privilege of this court to hear you. If it appears to be you are very thorough
No, my lord, I gone through in the morning, my
to
lord.
the law on appointment.
My lord, well, my lord, let it be on the after vacation, my lord. Otherwise, I will not come into it, my lord. If wants to fix here,
Why you want adjournment?
today, my lord, learned senior advocate PJ Soikia is out of station, my lord.
So you don't want the relief. You don't want the
No, my lord, next week,
petition
my
should
lord,
be allowed.
on 12th, my lord. On 12th, my lord. They have argued, my lord. And my lord, in this matter,
On
my
the
lord, I
prayer of Mr.
am Kalita.
M. Kolita, learned counsel for the petitioner. And the prayer not being objected to by the learned counsel for the respondents. List this matter after winter vacation. Since you are taking adjournment.
Yes, my lord. Can you fix it there, my lord? 7, my lord.
It is today's fix.
Lordship, with the consent of the LSC, I beg to mention item number 3, Lordship. I pray for adjournment for the day
Item number
3, Lordship.
3.
Lord, in this case, I'm appearing for respondent number 8. We also have some urgency, my lord.
That Joymala.
Joymala. Because we are concerned with the, my lord, welfare of that animal, my lord.
What happened after so many years?
No, actually, my lord, what had happened, my lord, Tripura High Court,
Is he safe? Is he
that's
safe?
what my lord, they're still under the custody of the temple.
Do you
So
have
we
any,
want that, this and
sir, do you
this
have
and-
any idea that whether she is in safe
not,
custody?
not in very good shape. Not in very good shape. Joe Tamil Nadu government has filed an affidavit, my lord.
Yes.
But going by the, my lord, in any case, my lord, there are rehabilitation centers. Central government, sorry, Supreme Court has approved those. High Power Committee has been constituted. Let the experts look into the matter. Our case is, my lord, the matter should be referred to that committee. Supreme Court has given a broad mandate to this committee, my lord, in these matters.
Lordship, our case is that we want the elephant back in the state of Assam. Lordship, let it be fixed on Monday, Lordship. The
Well,
learned advocate general will address the matter, Lordship.
May please, your lordship. Well, in this matter, I am appearing on behalf of Senior Counsel Mr. P.K. Tiwari, who represents the government of Tamil Nadu. Respondent numbers 2 to 5. Lord, on his behalf, I pray that the matter be taken up next week on Friday, my lord, because Senior Counsel Mr. Tiwari will be out of station. 13th, my lord. It's Friday.
On the joint prayer of learned council for the parties, list this matter on 13th.
12, Friday.
13. Can it be on 12th?
My lord,
Yes.
Yes, 12,
On
Lordship.
12th, my lord, I have some difficulty, my lord. Let it be on, either on 11th or 13th. my lord.
Lordship, 13th.
13th,
Lordship,
madam.
no confusion.
13th. The last day for this session. Anyway, I'll be here.
My
Try
lord.
let's say on
Deeply obliged.
May please, your lordship. Lordship, with the consent of the opposite party, I beg to mention for item number 11 today's daily list. Lordship, matter may be fixed after the vacation.
Why?
Lordship, my senior was about to appear, but he could not appear.
What
As
is the matter?
Lordship, it is related to the appointment of the petitioner to the post of a driver in the Guwahati High Court.
Driver.
Yes, Lordship.
Okay. Are you okay?
Lordship.
Have you been engaged? Are you still working? Are
No,
you
no,
working in
no,
the High
no,
Court?
Lordship.
Okay.
I am working, madam. I am
You
the
are
private
working.
respondent. I am working.
Obviously, you will not have any objection.
I will not.
Lordship, after the vacation.
On the prayer of Mr. N. Bora.
Myself, G.R. Singha, appearing on behalf of N. Bora, Lordship.
G.R.
G.R. Singha.
Hina, Learned Counsel appearing on behalf of Mr. N. Bora, Learned Counsel to the petitioner. And the prayer not be objected to the Learned Counsel to the respondent. Same is accepted. List the matter after
Vacation, Lordship.
intervocation.
Obliged.
May I request your lordships to kind first have, my lord,
Yes.
WPC number 6224 of 80.
Yes.
During the pendency of this case, my lord, an order was passed. That is why we have to institute the second proceeding. My lord, before I address your lordships,
Yes.
I may briefly indicate the background. My lord, what had happened, there are two basic cause of action. In 1988, my lord, there was a market of GMC in Fancy Bazaar, which was gutted by fire. Then thereafter, my lord, a situation arose
Yes.
as to where to accommodate these vendors.
Your vendors.
Yes, I'm vendor, my lord.
How many of you are?
Yes,
Is it-
my lord, we are, I think, 23, my lord.
23, yes.
Yes. So, my lord, the situation arose as to where to accommodate these vendors. There was a plot of land near that Matswa public station, my lord, which belonged to Handloom and Textile Department of Government of Assam. So, initially, my lord, they were accommodated there. In the site where that fire incident broke out, my lord, there the municipal corporation came up with a plan, my lord. They constructed a multi-storied building. There was sufficient delay. In any case, my lord, first round of litigation were there in the High Court as well as Supreme Court as to who are the vendors who are, victim of that fire incident. So that stage is over. Subsequently, my lord, apart from the fire victims of Fancy Bazaar market, there are other vendors who are squatting in this handloom land. So therefore, my lord, when in terms of the order of the High Court, the land was in fact given back to Handloom and Textile Department. Therefore, a second situation arose as to where to accommodate these vendors who are squatting. We fall in that second category. Then some of them were accommodated in Milord Ganeshguri market. Then thereafter this Pamohi area where Agriculture Marketing Board has its marketing yard that was identified. Now issue is Milord rehabilitating these vendors in Pamohi. That is the issue. Now matter went up to Supreme Court, Milord. Supreme Court also issued a direction. Ultimately, the direction of the Supreme Court, Lordships will get at Milord order at page number 45 of WPC 6224.
Yes.
Lord, the order is longish one. I'll have your Lordship's kind attention to page 45, para 20. If the markets are not constructed yet, they will be constructed by the government, the municipalities and other authorities in consultation with representatives of wholesale traders of Guwahati and allotment made within a period of 1 year from today. For this purpose, a committee shall be set up under chairmanship of the concerned Secretary of the Government of Assam and having members from representatives of the Guwahati municipality and other authorities, and also representatives of the Association of Wholesalers of Fruit, Vegetables and Grains, etc., as well as representatives from Electricity Department, Government, Water Department, Telephone Department, Police, etc. This committee shall form a rational plan for allotment of existing wholesale market inside the Guwahati city to new wholesale market which will be constructed if it has not already been constructed. All wholesalers inside Guwahati city shall be allowed to apply for allotment of adequate land for wholesale market at the outskirts or beyond the Guwahati city. If the applications are made, same will be decided in a fair and transparent, non-arbitrary manner without any pick and choose. The entire exercise, including the allotment, must be completed within 1 year from today. So this was the order of the Supreme Court, Milord.
Yes.
Thereafter, at page 47, Milord, an order was passed by the Guwahati Municipal Corporation, Milord. With reference to the subject cited above, I am to submit herewith a list of genuine and deserving applicants who actually applied for reallocation through Guwahati Shak-Pasoli Phalmul Paikari Byabasayi Sangha. The Sangha submitted a list of 113 number of traders for relocation at Pamohi. Following things mentioned below are found out on verification. 90 numbers of members are genuine who possess their voter identity as per the list enclosed. Out of the 90 members, 12 number of members are already running their businesses at Pamohi as per the list enclosed. 23 number members without voter ID out of 113, which have already informed to Guwahati Shak-Pasoli Phalmul Paikari Byabasayi Sangha to resubmit their identity. Now, my lord, now this list is at page 50, my lord, where all the name of 22 petitioners figure at page 50, my lord.
Yes.
So actually, my lord, serial number 1 to 7, then 10, 11, then 13, 14, then 16, 17, 19, 20, 24, 29, then my lord 35, 50, 53, 59, 63, 64 and 68.
Yes.
So they were identified, my lord. Thereafter, my lord, a provisional allotment was also made.
It's already marked.
Yes, at page 54, my lord.
Yes.
Kindly see, my lord, provisional allotments were made. Serial number 4, 6, 8, 11, 17. My lord, all the 22 petitioners are there in the ground floor,
23.
first floor, etc. Yes. Then up to 62.
Yes.
Then, my lord, at page 66, now this is where, my lord, the thing started to turn sour, my lord. This is where the mischief started. Now, all of a sudden, after identification and all, on 13 to 15, the commissioner, collector writes to this, my lord, Murtaza is the so-called secretary of the association. You are hereby requested to submit the list of wholesale traders evicted from Masqua temporary market connected with Supreme Court court contempt with copies of the following documents within 16 to 15 to the office of the undersigned. The documents which were asked for amongst others was trade license, license under so-and-so, etc., etc. Now this is where, my lord, the thing started taking turn. Then, my lord, the Mr. Murtaza, who is the secretary, he replied at page 67. Now, may I have your lordship's kind attention to first subpara. The undersigned states that since last 15 years, the undersigned have been battling in court for grant of permanent shop rooms to the undersigned Honta members, wherein your honor corporation had been a party to such proceeding, and furthermore, since the undersigned Santha members were having shops in temporary market for which your honor office declined to issue any trade license, and further undersigned members were shifted from one place to another, but on no occasion the undersigned members were allotted with permanent shop rooms. The undersigned also states that your honor corporation have already made survey every time the entire number of undersigned Santha, and after fully satisfying your honor's corporation by letter dated, forwarded the said letter to the CEO Agriculture Marketing Board, stating that out of 113 of the undersigned, 90 members of the Santha have been found genuine who can be allotted shop rooms at newly constructed market at Pamohi. The undersigned state that 90 members have also paid cess. The original slips of the cess has been deposited before your honor. So, one person to that notice, a reply was issued saying that out of that 113, 90 were identified, of whom we are also there. We were not issued any trade license at the relevant point of time because our that status was temporary, my lord, but otherwise we are paying cess regularly. Then, my lord, there was a proceeding before the Supreme Court regarding non-compliance of the order, which I read at page 45. Then this order was passed at page 70. Mr. Jitesh Khosla, page 70. Sri Jitesh Khosla, Chief Secretary, is present in the court along with Amlan Borwa, Secretary, Agriculture Department. It is stated before us that as far as the state is concerned, all necessary steps have been taken and it is possible to make allotments within a period of 3 months. We are also told that some petitions are pending in the High Court relating to similar subject matter, and that there may also be some grievances that require adjudication. Under the circumstances, we grant liberty to such aggrieved persons to approach Guwahati High Court in case there is any outstanding grievances in this regard. The contempt petitions are disposed of in view of the statement given by the Chief Secretary. So, recording the statement of the Chief Secretary, my lord, the contempt proceeding was closed. Thereafter, this, my lord, impugn order was passed that the lordships will get at page 71, which was assailed in this proceeding.
Yes.
In connection with the Supreme Court order regarding evicted traders of Masqua, and in connection with the decision on minutes of the meeting held on so and so, and the chairmanship of Chief Secretary Assam, a paper advertisement was published in 3 local newspapers requesting persons involved in the above cases and connected with Maskwa Wholesale Vegetable Market to appear before the hearing on 18/2/15 with the following documents in the office of the GMC to ascertain the genuine traders who were evicted from the Maskwa Wholesale Market. Further, Mohammad Murtaza, President Hakfasali Kolmol Paikari Bebokhai Khanta, was also issued a letter requesting him and his members of Santha to appear before the office of the commissioner with the following document for determination of the genuine traders who were evicted from Maskwa, etc., etc., etc. Murtaza, President of so and so, appeared before the commissioner, additional commissioner, and stated that he has submitted the list of 113 persons along with documents and photographs to CEO Agriculture Marketing Board, and these were the documents of the concerned 130 number of persons. The documents submitted to the Assam Agriculture Marketing Board were examined in presence of so and so, so and so, so and so. On examination of the then document, it was found that following 35 number of traders are genuine wholesale vegetable traders affected from Maskwa market. Where in this list, my lord, we do not figure. The reason is, my lord, we didn't have the trade license. And trade license was not given, it is an admitted position. Now kindly come to page 73. The rest 78 number of persons listed to submit valid documentary evidence like GMC trade license, Assam Agricultural Produce Market Committee license, copy of sales tax document, etc., etc., to confirm that they are genuine traders evicted from Maskwa. Hence, their claim could not be included in the list of the genuine traders evicted from Maskwa Wholesale Vegetable Market. So, my lord, the order which was by this order, those who did not possess trade license, etc., my lord, they were construed to be not genuine, and others, those who had, they were construed to be genuine. Therefore, these 35 were picked up for, my lord, discriminatory treatment. My lord, we challenge this order in WPC number 185/2015. My lord, in that case, initially there was a stay order. Stay order is dated. Stay order. Anyway, my lord, I think in the month of April 2015, there was an interim order maintaining status quo. Then, my lord, eventually, an application was filed by the corporation and all, that is IA 275015, for vacation of that interim order.
When this order was passed, you were already there, or you were not allowed?
No, we were not allowed, my lord. Yes. Till that, we have not been allowed. Now, what has happened, my lord? Initially, there was an interim order in 1825 of 15. The other side filed an application for vacating that order. That order is very relevant. That your lordships will get at page number 168 of 1330 of 24. I can put the option. 1330 of 24. Page 168. Extra copy আছে নি? Photo দিয়ে দিন যে। Yes. Milord, it starts at page 168. Milord will kindly come to page 171.
Yes.
The first subpara
But the same
at
petition-
page 171, Milord.
But the same petitioners.
Yes, yes. This order was passed at the instance of the present petitioners. There was a stay vacation petition by GMC, which was rejected, GMDA, which was rejected by this honorable court. There, I would like to have your lordship's kind attention. Page 171, first subpara.
Yes.
A.B. Chaudhary, learned senior counsel appearing on behalf of GMC, has not disputed the genuineness or otherwise of the letter dated 9/7/14 and of NHL 4 dated 28/1/15 in regard to provisional allotment of shops in favor of writ petitioners. It is the case of Mr. Chaudhary that High Power Committee headed by none other than Chief Secretary subsequently considered the whole matter and thereupon arrived at the finding that present petitioners failed to establish their genuineness, and it is under such circumstances a new exercise had to be made. According to Mr. Chaudhary, writ petitioners could not produce any material whatsoever in support for which their names have not found place in the order dated 25/2/15. That, my lord, that 35 were identified. After hearing the learned counsel for the parties and after perusal of the aforesaid documents annexed to the writ petition, it appears that present petitioners have succeeded to set up a prima facie case that they were wholesale traders in Moskwa before they were evicted in the year 2008. Letter dated 9/7/14 issued by GMC is a pointer to that fact, where they were initially identified. GMC at some point on 28/1/15 had issued provisional allotment order in favor of the petitioners along with others, but subsequently it was not favored by the High Power Committee, but for which the present petitioners have not been allotted shops till date. Now that as many as 94 shops have been constructed and another 82 are on the verge of being completed, the present petitioners would be entitled to be considered for allotment against them, provided they establish prima facie that they were evicted wholesalers from Moskwa. Anyway, my lord, the stand of the GMC was not accepted. That is why, my lord, the interim order passed in favor of the petitioner was not vacated. No, GMC, vacating. Finally, my lord, this writ petition was closed. That your lordships will get in the writ petition at page number 77. 77, my lord.
662.
Yes, 6224.
622. Yes.
Yes. Now I'll have your lordship's kind attention to the first subpara. By this writ petition, petitioners are aggrieved by letter dated 13/2/15 issued by the collector, Guwahati Municipal Corporation, and order dated 25/2/15 of the Guwahati Municipal Corporation, by letter of 13/2/15 addressed to one Mohammad Murtaza, who is stated to be secretary of the association comprising of the petitioners herein. The said secretary was requested to submit the list of the wholesale traders evicted from Moskwa temporary market in connection with contempt petition in Supreme Court. The copies of the documents sought for were so and so. By impugn order dated 25/2/15, the Commissioner, Guwahati Municipal Corporation, a list of 35 purported traders has been mentioned, who are either required to have its copies of the GMC trade license or license issued by the Assam Agricultural Trade Marketing Committee. By the said order, it has been provided that apart from the list of 35 purported wholesalers, the rest 78 who had applied for allotment of shops in the newly shifted premises at Pamohi had failed to submit any valid document evidence like GMC trade license or Assam Agricultural Trade Marketing Committee, etc. It is the submission of the learned senior counsel for the petitioner that wholesale traders who were operating from Moskwa area were operating their business in such a temporary manner, and most of them do not have GMC trade license or AAP's MCA license. And at that relevant point of time, when they were operating their business, such requirement was not a mandatory requirement. It is submitted that petitioners are operating their business by obtaining receipt issued by the Agricultural Marketing Board for payment that they had made for operating the business. On the other hand, the provisional allotment list dated 28/1/15, which petitioners 6 and 4, is a list of 78 number of wholesalers who have been allotted different shops in wholesale market at Pamohi, and same reads as follows. The learned standing counsel for the board opposes the direction for giving allotment as per the said provisional list on the ground that the order of the Supreme Court dated so and so, it has been provided that a committee shall be set up under chairmanship of the concerned secretary of the government of Assam, having members from representatives of GMC and other authorities, and also representative of the Association of Wholesalers, as well as representative from Electricity Department, Water, etc. It had further been provided that the said committee shall form a rational plan for allotment of the existing wholesale market inside Guwahati city to a new wholesale market, which had in the meantime been constructed at Pamohi. It is submitted by Learned Standing Council that provisional list which is required to be enforced had not only been made by the aforesaid committee as directed to be constituted by the Honorable Supreme Court. Upon considering the rival submission of the parties and without going into detail of the entire factual background of the case, one issue to be decided is as to in what manner the wholesalers are to be accommodated in the new constructed market at Pamohi. On one hand, submission had been made by petitioner is that authorities are asking for certain documents to be produced which the wholesalers do not have, and on the other hand, the respondents are of the view that such documents are necessary. For the purpose of making the allotment, in order to decide the issue, notice had also been taken that at the relevant point of time, when the wholesale business was undertaken in Maskwa, the requirement of trade license was not enforced, and as a result of which some traders may have trade license while some may not have. As the entire arrangement was a temporary arrangement, be that as it may, all traders involved therein have been paid required amount of the GMC authorities, and therefore the said amount can also be the basis, said document can also be the basis to identify as to which of the traders were undertaking the business at that point of time. In view of the aforesaid submission made by the Learned Council, and now kindly mark this one, and upon agreement of all parties, this writ petition is proposed to be disposed of with the following directions. It is also taken notice that the notification dated 28/8/12 under the signature of Principal Secretary, the Government of Assam Agriculture Department, committee referred by Supreme Court in its order dated 29/8/11 had already been constituted. The said committee, as mentioned in the notification, is as under. So, my lord, this committee would consist of the following. Now, my lord, at page 81 are the relevant directions. The committee constituted by notification dated 28/8/12 will conduct a de novo exercise to determine as to who is to be given the allotment in the new wholesale market situated at Pamohi. While deciding de novo, the committee would first examine the cases of the petitioners and other similarly placed wholesalers who are conducting their business in the temporary area at Maskwa and who are required to be shifted as per the order of this court and also the Supreme Court. While initiating exercise, the aforesaid committee will first formulate a guideline indicating the documents that were required to be submitted by wholesalers, and the said guidelines will be widely circulated among all the intending allottees. After guidelines are formulated, in the event the intending wholesalers are of the view they do not possess any of the required documents, the individual wholesalers shall make an application before the appropriate authority granting the required document for issuance of the same. Upon such said application for grant of documents being made, appropriate authority being either the GMC or Agriculture Marketing Board or any other authority shall immediately, prefer within a period of 10 days thereafter, grant, issue the document on the event of refusal, give a reasoned order for the same. If somebody doesn't have a trade license, if it is applied, it will be given within 10 days. If it is not given, then the reasoned order will follow. And we all apply. Upon the aforesaid exercise being carried out, and then after all the intending holders are in possession of the required document, the process of allotment would be started, wherein existing wholesalers at Maskwa, including the writ petitioners, would be considered first, and thereafter the committee may consider the applications of any other person who was not a wholesaler earlier at the market. So, these are the guidelines. Now, kindly come to the next page, very important, my lord. It is further provided that while making the allotment as indicated herein above, a respondent authority will neither take into consideration nor will be influenced by earlier order dated 25/2/15. That is the order by which, my lord, the 35 were found to be valid and 78 is not. So, my lord, there was also a direction that 25/2/15 will not be taken note of. Now, thereafter, my lord, the government of Assam framed a guideline. Now, my lord, if your lordship would kindly take the, just for maintaining seriatim, my lord, take the affidavit of the respondent, my lord, where it is annexed. If your lordship would kindly take the affidavit filed by Assam State Marketing Board, my lord. I think it starts at page 156. May I have your lordship's kind attention to page 167. Pursuant to that, my lord, this guideline was framed, where also we fit in.
Additional affidavit.
My lord, an affidavit filed by member secretary, Assam State Agriculture Marketing Board. No, 6224. No, it is. Huh? এইখন লাগে।
এইখন আমি ফাইল লৈছো হেৰি
Page 170, 50,
136
136. My lord, may kindly come to page 136, my lord.
ৰানিং পেজত
Confusion over this.
মানে ৰানিং পেজত খেলি
My lord, I think it's a second affidavit filed by the board where the guideline is annexed.
136, 137.
Yes, my lord. An affidavit filed by member secretary to the committee is that the heading, my lord? An affidavit filed by member secretary to the committee chief executive officer.
Vidyut Vikas Bhagwati.
Yes, yes, yes.
Additional affidavit.
Yes, yes. My lord will kindly come to internal page number 12 of the affidavit. This is the guideline. Education law cool is it? 147. ठीक है सर. $147 million. Guideline for allotment. Heading.
It is page 167. This is second, this is
Yes, my lord.
156. Yes.
I'm reading the relevant portion, my lord. The shops at Pamohi market will be considered for allotment to the eligible wholesaler from the following. Those who have been doing business at Pamohi market, including writ petitioners of WPC so-and-so, we do not fall in this category. Now B. Those who were doing business as Masqua before their eviction by concerned authorities in the year 2005, including writ petitioners of 1852. So we are included. So we are covered. Now, my lord will kindly come to serial 4. The prescribed application form should invariably be accompanied with the following documents. In case of the wholesaler following in the category 1A above, the following, we are not 1A, so we are not concerned with this. My lord will kindly come to the next page. Please come to B on top. In case of the wholesaler falling in the category 1B above, to which the category we fall, any one of the following documents showing evidence of their doing business at Maskwa market before their eviction must be furnished. Trade license issued by the Guwahati Municipal Corporation, municipal tax receipt, etc. The license as trader or commission agent, etc., etc. So, my lord, there was a direction of the learned single judge that will apply within 10 days, they will issue us. In any case, earlier we are already identified. Now, 5. For both categories of, yes. And all these documents we have already submitted before the GMC authority, original. For both categories of wholesalers, that is 1A and 1B above, the following documents for KYC requirements must be furnished. And my lord, KYC requirements, these were prescribed. 6. In addition to the above, both categories of wholesalers, A and B, must furnish an undertaking by an affidavit to this website. And my lord, these are the requirements to be followed. Then if your lordship will kindly come to the next page, serial number 8.
So trade lines, obviously you would not.
No, we didn't have, but we applied, my lord, in terms of the order of the learned single judge. Then please come to serial number 8, my lord. After finalization of list of eligible wholesalers, the committee will make allotment of available shops numbering 45 by way of lottery in a transparent manner. This order is under stay, my lord, as on date. Initially. So this order is still.
Which order? This guideline?
Yeah, no, not guideline, allotment. Allotment of room pending finalization of the present proceeding. So, my lord, these are the modalities. So, basically, my lord, all that we are supposed to give was either a trade license or some sales paying receipt. We, in fact, my lord, we submitted sales paid receipt and we also submitted all our original document before the BGMC authority asking for trade license in terms of the order of the learned single judge.
Any one of the following documents?
Yes. Now, my lord will see how they are dealing with the issue. Now, lordship will come back to the writ petition. I refer to that, my lord, guideline just to maintain the seriatim, my lord. Then, my lord will kindly come to page number 87.
Yes.
Now, this is a minute, my lord, of the, it was this proceeding was held under the presidency of chairmanship of the Secretary Agriculture. Now, with reference to the above, I have the honor to inform you that as per direction of the government by this letter under reference, a meeting of committee constituted by the government of Assam in pursuance of the order of the Honorable Supreme Court will be held on 26/6/18 at 11 a.m. in the office chamber of the Secretary, Government of Assam Agriculture, so and so, for discussion on the matter relating to allotment of remaining room shops at Pamohi, along with other related matters, as per order dated so and so of the Guwahati High Court in WPC number so and so. Well, this notice was never served to the petitioner. Instead, it was given to this president of the secretary, whom he does not represent. You were therefore requested to kindly attend the meeting as scheduled. This as the approval of the chairman. So, my lord, at page, now please come to page 88. What is the agenda for discussion of the meeting? For filling up remaining 48 rooms, amongst others, prayer for allotment of rooms of some candidate as referred by various MLAs and ministers of Assam. Supreme Court never gave this direction, my lord. As per agenda 3, prayer for allotment of rooms of sub-candidate as referred by various MLAs ministers are shown below. So, my lord, Agriculture Minister recommends one Prolokya Deka. Then Chairman, Assam State Agriculture Marketing Board referred to one Bhagavan Das. Then Agriculture Minister referred to somebody as Montu Thakur. Bimal Das by Mr. Raman Kolita. Then Abdul Kasem and Bimal Das by West Guwahati again, Raman Kolita. Hiren Chandra Kolita by Veterinary Minister. And Jitumoni Kolita by 5 Minister. So, my lord, by accommodating Minister's request, rules are-
But it's not isolated. It's the common all over the country.
all over the country. My lord will kindly come to page 90.
Yes.
With reference to the above, I have the honor to inform you that due to some unavoidable circumstances, the scheduled meeting of the committee to be held on 17/7 in the office chamber of the secretary for discussion on the matter relating to allotment of remaining shops in Pamoi has been postponed. So again, the meeting was postponed. Then my lord will kindly come to page 91. Again, the meeting was rescheduled, my lord. In the meantime, my lord, we get to know. And my lord, apart from the fact that the committee is not in accordance with the direction of the Supreme Court, they were more interested in, my lord, acting on the recommendation of the people's representative. Now, if your lordship will go back to that affidavit, my lord, which wherefrom I referred to the guidelines.
Yes.
Now, this is the impugned decision, my lord. Therefore, we have to file the subsequent writ petition.
This.
Page 171, I think, my lord. This is dated 26/3/21. Has your lordship got it, my lord?
Yes.
Yes. Now, kindly see, my lord, who all are the member present? Secretary Agriculture, okay. Then CEO Assam Agriculture, okay. Then Navodip Sangmai, okay. Orup Kumar Fukon, PWD. Now, who are missing, my lord?
Secretary President.
Yes. My lord, electricity is not present. Police is not present. Water is not present. As prescribed by the Supreme Court's order. Now, what they do, kindly see, my lord. The meeting was held in the office chamber of Secretary, Government of Assam, in so-and-so. The meeting was chaired by Secretary. At the outset, the chairman welcomed the members present in the meeting and requested the members to proceed as per agenda. The committee perused the order of the Honorable Guwahati High Court in WPC number 6224 of 18 and also examined the application of the petitioners placed before the committee by member secretary. The committee, after threadbare discussion and examination of applications submitted by the petitioners, found that applications do not fulfill the required criteria as per the guideline formulated in pursuance of order dated so-and-so of the Supreme Court, including order dated of the Guwahati High Court in WPC number so-and-so, so-and-so, so-and-so. The committee advised members to apprise the standing council. Anyway, my lord, in this selection process, we were not considered. And we understand the reason is, my lord, we do not have a trade license. Can that be done, my lord? When the coordinate bench of this honorable court in the judgment has categorically said, if we do not possess any document, we will apply, they will give us within 10 days. And my lord, the honorable court, the coordinate bench.
As per the guidelines, that's not the only one of the documents.
Anyone,
like trade license.
anyone. We have, my lord, in fact, we submitted all. Because the Lordship will kindly appreciate one thing, in that order of the coordinate bench, one aspect was taken note of. Considering that the arrangement was a temporary, because that was being held in the premises of Handloom and Textile Department. Therefore, my lord, they were not insisted upon trade license. That's why somebody had, somebody didn't have. But Nevertheless, my lord, everybody paid that cess, that fee which is being charged by municipality for spatting on the room. And that is admitted. So, my lord, when that order of the coordinate bench has attained finality, where the honorable court bench also said that 28 to 15 order you cannot take note of. The learned single judge also took note of the fact that earlier we were identified as the genuine vendors. Now, what happened in between? Trade license absolutely cannot be the reason. So that is why we are before our lordships, my lord. And this 45 allotment as on date is on hold because of the interim order. So, my lord, this is not a rocket science, my lord. End of the day, it's an issue of relocation of the vendors. So, my lord, all that is required is some proof, and we have furnished, my lord. Let them say that we have not furnished the proof. And they should also explain, my lord. Now, in the subsequent writ petition, we have challenged this order dated 26/3/21.
Same petitioner.
My lord.
Same petitioner.
Same petitioner. Because, my lord, during the course of the proceedings.
This subsequent 26/3.
Yes. That is challenged in, my lord, WPC number 1330 of 24. And there, my lord, at page 173 is that minutes dated 26/3/21. In fact, my lord, a coordinate bench of this honorable court, while hearing the matter, my lord.
This 1330/2024 is only it's the same thing. You are
Same
just
thing, only that we have
challenging this.
Yes, subsequent. Because it was observed by this honorable court, might as well we also put a challenge to it. That is how we did it. And if your lordship would kindly take this 1330, my lord, for a moment.
Yes.
Kindly see, my lord, page 147 onwards. Trade license deciding, na? Trade license.
So that is what I was about to ask.
So,
you.
my lord, this is the application of petitioner number 1.
These are the application and the documents.
Yes.
These are the documents.
Now, what we have applied for, kindly see, my lord. Trade license applied for as per order dated 9/2/17, passed by the Guwahati High Court. Tax payment receipt. So, my lord, the Aadhaar card is there. So, this is how, my lord, we have applied for the requisite document. Then at page 151 is the land document. Then is the an affidavit filed before the notary public. And just as a sample, my lord, we have given what all are the documents which we have applied for. So, my lord, this is how we apply. Our cases have not been considered. My lord, our simple case is, in terms of the judgment dated, my lord, which was a consent order, my lord, 9/2/17. 9/2/17, that's the final order in, my lord, 1852 of 2015, where everything crystallized, my lord. So, therefore, non-consideration of our case, in my humble submission, is arbitrary, my lord.
Where are you now?
My lord.
Where are you now?
Now, we have not been allotted. We are doing some squatting, doing and all, my lord. But then we have not been allotted room. And regarding allotment, there is a restraint order from this order. So I respectfully pray, my lord. So authorities should, dispassionately consider our case.
Kindly have a look the order dated 12/2/2021 passed in WPC number 6/2024. 12/2/2021. In the first case.
Twelve
2/2021.
21.
So the petitioners never participated in the process of selection of the room, Lordship. So, Lordship, as per 12 to 2021, Lordship, I may read the order, Lordship.
12 to 2021.
2021.
Yes.
Heard Mr. So, in view of the submission made by the Learned Council and in terms of the order dated 9 to 2017, Lordship, that is the order, which referred by the Senior Council, Lordship, as in WBC 1852, necessary guidelines shall be served on Mr. NNB Chaudhary, the Learned Council representing the petitioners, who shall accept on behalf of all the petitioners. The said process shall be completed within a period of 15 days from today. Within the next 15 days after expiry of the period of serving the guideline, the petitioners shall submit the applications along with required documents, Lordship. After completion of the period for submission of the applications, the respondent committee constituted by government notification number so and so, as referred to in the order dated 9 to 2017 in WBC 1852, Lordship, shall pass necessary orders on the basis of the application within a period of 15 days from the date of closure of filing of application, Lordship. The action taken and the order passed by the committee shall be placed before this court on the next date fixed, Lordship. Accordingly, the next date fixed on 30/3/2021, Lordship. Also, we provide them the documents, Lordship, the guidelines, Lordship. Accordingly, they applied, Lordship. After that, Lordship, can you have a look at my affidavit in opposition, Lordship.
Page
Lordship, 174
174
in 6224.
in this petition.
Yes, Lordship.
174.
174.
Yes, this 173.
192 is the comparative statement, Lordship.
No, this is something. 174.
Start from 174.
This is a reply.
Additional affidavit, Lordship. Oh.
173.
Start with the 174. Start from 174.
174 is the next page of the reply on behalf of the petitioners to the additional affidavit. This is additional affidavit.
I find additional affidavit on, Lordship, dated
An affidavit by the member secretary
Lordship.
filed on 8 March 2023.
Lordship, file on, Lordship.
Compliance of the.
8 March, yes, Lordship, 8 March.
Yes, it's page 156.
153.
Yes.
Lordship, the Annex 5, and have a look at the Annex 5. The comparative statement, Lordship.
Annexure.
Annex 5, the comparative statement.
Annexure 2. Annexure 3. Notice. There's no annexure 5.
No, it's not. So can you have a look?
There's no annexure 5.
In my case, it is 192. Come on.
It's up. Your affidavit contains only two.
Yes, my affidavit contains those. Yes.
No, only 3 annexures. There's no annexure 5.
That is there also.
Up to annexure 3 only.
ছয় মাসত 20. আচ্ছা এবার আছে Kali Lordship, allow me to check the record.
Yes. It's only consists of three annexes only.
Itu 192.
Then next is notice. Do you have the annexes?
Yes, ma'am. Yes, sir.
Annexes 5.
Also, here it is 192. Board item. No.
In addition, that we did
192.
11 March. Please, in addition, activity proceed. 156. What is this? 8 March. Okay, you have filed 2 additional affidavit.
So we have filed three additional affidavit.
This is the second one, 11 March.
One affidavit, 2 additional affidavit. Lordship.
Additional affidavit. Yes,
Also, kindly have a look the documents submitted by the petitioners. Lordship.
yes.
The column application form duly fill up. Lordship. Aadhaar card, affidavit as per the guideline issued by the committee. Lordship. D is a copy of the application dated 6/20/2021 applied for the trade license from GMC. Lordship. E is also a copy of the RTA application dated 8/2020 addressed to the collector and public information officer GMC requesting to furnish sales paid documents. Lordship. 5 the sales payment received for the year 2015. Lordship. This is the documents they have submitted. Lordship. As per the order dated 12/2/2021. Lordship. And in accordance with the order dated 9/2/2017 passed in WBC number 185/2015. Lordship. So they never fulfilled the required criteria for allotment of room. Lordship. So Lordship, after that Lordship, in 6/2/2024, there is an order dated 12/2/2024. There is another order passed in WBC 6/2/2024 dated.
No, you will just clear this. These are the documents.
Lordship, they have submitted. Lordship.
These are enough.
No, Lordship, they have not submitted the trade license. Lordship.
Sales payment received for the year 2005-15.
Sales
Trading
payment-
license, have you issued the trading license?
No, not they are not wholesaler. Lordship. That is the issue. As Lordship, kindly for a moment look the guideline. Lordship. Guideline
Any
especially-
one of the documents.
Lordship, they have
Not
to
all the
wholesaler.
documents.
As a wholesaler, Lordship, not as a vendor. They have to wholesaler. They must be wholesaler. Lordship. As the guideline says that they are wholesalers.
Where is the guidelines? Let's come back to the guidelines.
So,
Page 168.
Lordship. As per guideline, Lordship,
In case of the wholesalers falling in the categories 1B,
Lordship,
above any one of the following documents showing evidence of doing their business in Machkua. You just come to serial number Roman 4. Says payment receipt.
Lordship, they submitted documents for wholesaler, not for any vendors, Lordship.
See, says payment received in K form issued under Rule 21 of so and so. That's all.
Lordship, for you may have a look the order dated 12 to 2024 in.
Just wait. You have said says payment received for the year 2005. It's enough. You are not saying that it's not as per the rules.
No, Lordship, guideline clearly stated that the
Come to guideline page 168, please read it.
1B left falls in 1B, Lordship. On the next page, Lordship.
Just read it. Guideline, one page 168.
B, Lordship, next page,
Yes.
in B, in case of wholesalers, Lordship.
In case of wholesalers falling
In categories 1B. 1B above and any one of the following documents showing evidence of doing their business at Machkua Market
Yes.
before the eviction must furnish, Lordship. One, Lordship, the trade license issued by the Guwahati Municipal Corporation, Lordship. Secondly, municipal tax payment received Guwahati Municipal Corporation, Lordship. Third is the license as state trader or commission agent issued by the Guwahati Sub-Regional Market
It's okay, it's any one of the documents.
Lordship,
Out of these four
they have not
documents,
submitted, Lordship.
Sales payment has been submitted. You have recorded it. Come to your comparative.
Lordship, only
Sales payment received for the year 2015.
2015, Lordship, only one petition, the others not yet
Then
submitted.
the remarks is that required documents showing evidence of doing wholesale business
At Machkua before eviction not
before
submitted.
eviction is not submitted.
Lordship, they
But the
have not
question
submitted.
of wholesale or something like that, are you differentiating the between the distinction between the wholesaler and the vendor?
Yeah, there is a distinction, Lordship.
So the issue is for
that
the allotment of the shops to the vendors, not the wholesaler.
The Pamoy market, Lordship, especially considered for only wholesalers, Lordship, not for the all the vendors. Pamoy market considered only for the wholesalers.
So you are in a different track then in
No,
that
that's-
case. But the Supreme Court says so.
Yes, Lordship, as per Supreme Court says, guideline, we formulated guideline, Lordship.
Yes.
Guideline clearly stated that they
Are you saying that these petitions doesn't fall under these guidelines?
Lordship,
That
they falls
those
in
who were
category
doing
1B, Lordship.
Those who were doing business at Machkua before their eviction. It
Lordship,
doesn't fall under these petitions. Doesn't fall under this.
Lordship, the petitioners, they falls under category 1B, Lordship, the
Yes.
1852, WC
Then-
1852.
Then,
Lordship, they never submitted the documents for.
sir, issue you have to relate back to 2008. These are the persons who went up to Supreme Court, came back, guidelines, everything. These are for them only. Wholesalers or whatever, they are not well concerned.
Lordship, in 6 to 2024, at this
Thereafter, this court has clearly passed a direction.
direction was given,
But
they
it-
applied for license within 10 days, but they never applied, Lordship.
Forget about this. This guidelines, are you for saying that it is applicable to the petitioners?
Lordship,
Is these guidelines applicable to the petitioner?
Lordship, petitioners, applicable
Then-
to petitioners. Lordship, for which Lordship kindly have a
Then
look
you
the
have
order.
said in the guideline, any one of the following documents, though you have said wholesaler. That's why I'm asking, is there any distinction, are you distinguishing is there any difference between the vendor and the wholesaler? If you are saying that this is only for wholesaler and the petitioner is not vendor, then you are on the you are off track.
Lordship, for a moment, have a look the order dated, Lordship, passing this case, Lordship.
Let us clear this first. What you are submitting is that these guidelines applies to them.
Lordship,
But then since they have not submitted the required documents,
Okay.
they cannot be allotted.
Lordship.
So these guidelines says any one of the documents, forget about other documents. They have submitted the cess payment which you have recorded.
The cess is recorded, Lordship.
So any one of the documents. So there is no dispute that these guidelines applies to the petitioners.
They have
And if
to,
it applies, only what you have to see is, if they submit all the documents, it's well and good, it's fine. But if they fail to, if they can submit any one of the documents, it's enough. Is not it?
but they have not submitted the documents for lordship.
Sir, what you have said is what? Read it again. Any one of the following documents showing evidence of doing their business as Machkwa. So, we'll not forget about others. Serial number Roman 4. Sales payment receipt in so and so, so and so. Then come to your comparative statement. Forget about others. You see sales payment receipt for year 2005. You have not said in remarks, you just require documents showing evidence of doing wholesale business at Moscow market before eviction is not submitted. Once the sales payment is submitted, within one of the documents.
Lordship, Master evicted in the year 2008 lordship.
Yes,
In the year 2008 lordship. Not in the year 2015 lordship.
whatever, you have not said so.
Lordship says is only the final, so this is not the actual
No, you
document
cannot
lordship.
go into all these things. I think, sir, because of the so many. Much water have already flowed. Yes, then next.
Lordship, in 62 they have already, my lord, the
So
coordinate
therefore,
was-
appears to be the rejection is appears to be arbitrary. Yes. Then
in 622, then nothing remains for application lordship.
Yes.
Already there is an order dated 12 to 2024.
12 to
2024. Kindly have a look this order lordship.
12 to
2024.
12
12 February.
2024.
May I read lordship? The record reveals that pursuant to the direction passed by the Supreme Court of India in its judgment dated 29/8/2011, passed in civil appeal number so and so, and the order dated passed by this court 9/2017 in WBC number so and so, a set of guidelines was prepared on 12/6/2017 by the committee which was constituted in terms of with the notification number so and so dated so and so. A perusal of the guidelines shows that the eligibility of the applicants has to be tested in terms with the clauses 4, 5, 6, 7. The petitioners herein fall in the ambit of category 1B and therefore specifically required to have the eligibility in terms with clause 4B of the guidelines dated 12/6/2017. A question arose during the course of hearing that as to whether clause 4B, 3 and 4 would be applicable in case of the petitioners to which Mr. So-and-so, the Liner Council appearing on behalf of the marketing board, submits that in aspect of the category 1B, there was no requirement in terms with the 4B, 3 and 4. He however submits that the petitioner herein did not satisfy the condition mentioned in clause 4B, 1 and 2, and it is under such circumstances the decision taken on 26/2021 in the minutes of the meeting of the committee thereby rejecting the applications of the petitioners. This court, however, finds very pertinent to observe that this rejection have not been put to challenge, and under such circumstances, without a challenge to the said documents, nothing remains to be adjudicated in the instant writ petition lordship. That is the order lordship.
Yes. How do you,
624.
what he's
nothing
saying
remains.
is that this court has already observed
Yes,
that
625
there is
is done,
nothing
Lord.
to be adjudicated without challenging this rejection. That
That's
com-
what-
That's 625.
That's why we have challenged the rejection in my lord, this new petition.
Also in
This
similar,
one.
similar
Second,
issue
yes.
lordship.
1330.
Yes.
Lordship, in similar
In fact,
matter-
that is the reason we filed that.
Lordship, another coordinate already held in
No,
same
no,
issue.
it's
lordship.
okay. What you we are relying that this rejection has not been challenged now.
Now the reason
Are you trying to
challenge
show
now
that?
in the new case, Lordship.
Yes.
Lordship, have a look this order, Lordship.
So
Passing.
if it is in the new case, if it is challenged after this, we're hearing both the petitions.
In fact, Lordship would recollect, I pointed out that during the course of this proceeding, it was pointed out, observed.
Yes.
That's why we filed the
Yes,
new.
yes. This
Lordship,
2024.
Lordship, in this case, there's another case, Lordship, that is the Murtaza Lordship. Yes, WBC 1347, same issue. They have not submitted, this document, only sales documents. The coordinator has disposed of the matter, Lordship. Let's kindly have a look this order.
No, that is different.
It is same, Lordship. The Murtaza is the President Secretary of the Sakpachuli Hamtha, Lordship.
We have come in our individual capacity.
Who is this Murtaza?
Murtaza is the President Secretary of the wholesale market. Lordship. That is, they have also challenged the for allotment of room, Lordship. Coordinator already disposed of that. This one.
In view of the above mentioned committee, our committee এই কইছে
The Murtaza also falls in category 1B, Lordship, as per the guideline, Lordship.
they will avail
Yes.
remedy. They have not availed.
This case has not been rejected.
That they did not avail their remedy, that is their headache. How that will govern us?
Yes.
We
It has not been, the issue has not been determined. It has not been adjudicated. They have chosen to approach the appropriate, avail the appropriate remedy, that's all. No adjudication on merit.
So in one case, we have filed a affidavit, Lordship, and here my affidavit, Lordship. We have
That is your
in
affidavit.
affidavit category stated what happened. We have
You have seen what had happened. That's all. So your case is that since they don't have the required documents, particularly to show that they did a business at Machkua, that they don't have a document to show that they did a business at Machkua, therefore their case has been rejected, even if there are some other documents. Right? That's all.
So they have not. Also, can you please another? I will satisfy my Lord in one.
No, I'm already satisfied. Is
Some
it your
more time is
case?
required, Lord.
Is it your stand? That's all. Next week.
No, my
We'll
lord.
keep it part
Next,
half. Next week.
Part.
Also, part
I'm
of
giving you 1 week time.
also,
4 days time. Or 5 days.
then,
We'll not hear you. We'll just hear him.
Only can I just point out two things, my lord?
Yes.
He says we are not wholesale dealer. This court has already recorded a finding. I just saw that.
That's okay.
Yes.
No, of course, you will have a right to
Right
reply.
away.
Since he's seeking time, let us give him an opportunity.
so next week, I'm Lord.
Next week, huh? We'll keep it part half. I have understood what you wanted to submit, but
That's
then
it.
have you understood what I?
What's I understand?
Your case is that forget about other documents. Let us boil down to a particular your that remark. That petitioner could not show any documents that they were working, they were running a business at Machkua. But your guideline says that any one of the documents. So they have other documents. We'll see, but then at least the sales payment has been submitted. So that
Regarding
could be
wholesalers-
one of the documents.
Regarding wholesalers, there should be a trade license.
And according to them, they have already applied for a trade license. as per
In
the
terms of the
direction.
order of the
Yeah.
coordinate bench.
But you have not granted that.
Actually,
I am not for the GMC.
he
I
is
am
for
the
the marketing
I am
board
for the marketing
actually.
board.
Okay.
The GMC authority will.
Who is to the GMC?
My colleague is the
We
GMC.
only verified, Lordship. Lordship, why I'm stressing the point wholesaler, Lordship. Lordship, may please come to the first judgment, Lordship, of the Supreme Court as page 37. Lordship comes to the operating portion at page 46.
Yes.
All wholesalers. So
Oh.
this is open for wholesalers only. So first they have to satisfy the authority that we were wholesalers at the Moscow market.
Therefore, what you are trying to say that they are not the wholesaler. They are
Because
just-
they don't have trade license.
They are unable to show any documents that they were wholesalers at the Moscow
Sir, I
market.
think it's too far-fetched.
And no, that was the criteria even
Ridiculous.
before the JMC authority.
All along after the Supreme Court, they have been approaching
The
this
Supreme
court
Court clearly mentioned it's
in
wholesaler.
UADA.
No.
Let us not read the one
And
word.
GNC initially recommended us.
Sir, let us not read only the one meaning of the one
No,
word.
in all the
We'll have to read the entire thing.
yes,
Here
in
are-
all the Lordship will ultimately come to the operative portion. In all the judgments, Lordship will find the word wholesaler.
It has to be read together. It has to be read
Lordship,
together.
Lordship, he will satisfy. I will also satisfy your Lordship on the next day.
And next
But
day we will
Lordship
satisfy.
will not keep the entire issue generalizing the entire.
No, I've not.
It's
That's why.
for settlement of specific
That's why
category
I
of
was
traders.
making. I mean, deliberating with him. That's why I said maybe my understanding of his submission may be wrong. Maybe I may not have correctly understood. That's why I was deliberating.
Probably he is not able to.
You may try to satisfy. We may not satisfy also. You may try to convince. We may not be convinced
Yes.
also.
In fact, Lordship,
Of
our
course, subject
entire-
to best of
Lordship,
our knowledge and
exercise for
ability.
verification was based on one criteria only, whether they were wholesalers in the Moscow market
Yes.
or not.
That's why
We
we are
have done the
granting the time.
requirement of other documents.
He's seeking time. That's why. Otherwise, you can finish it today also. No issue.
Allah, 11th minute.
I heard Mr. Ken Chaudhary, London Senior Counsel, Assistant NNB Chaudhary, and also heard Mr.
MJ Gogoi,
NJ Gogoi, London Standing Council
Standing Council.
for Agriculture.
Agriculture Marketing Board.
Yes, MD.
You are the one who allots the.
Yes.
Okay, and who has taken the decision
They are operating the
also.
market.
We are the. I am the member secretary of the committee, Lordship.
So you have taken the
We have taken a
decision,
decision.
Yes.
including the department.
Along with the other department.
Who is for agriculture? Then
I for James.
PNAG, then Standing Council, James.
I'm for 1 and 2 others.
Yes. Hearing remain next para inconclusive on the prayer of London Council for the respondent. Is this method is this method in the next week on 11th?
Yes.
11, 12. No, sir. Mr. Nayak, don't take it that it's my final. I mean, we have not heard it. I mean, we have not completed the hearing, and then we'll have to see what's there. I've understood what they're trying to indicate. Anyway.
Lordship, here in this case, Lordship, the record not received, Lordship.
What
So
is the
far,
matter? Builder,
Lordship.
why you have not, you are directed to produce the record?
Yes, Lordship, but the record, Lordship, what happened, Lordship, earlier,
Not
Lordship,
this- When do you want?
Lordship,
No point without record.
January, Lordship, first week of
Lordship,
January.
before vacation, your Lordship.
Before vacation, Lordship,
Can you produce before vacation, somewhere
Lordship,
after 17?
it will be difficult, Lordship, before vacation. Because, Lordship, what happened, Lordship, earlier, Lordship, he was in.
Lordship, it's 2015 matter, your Lordship.
Yes, Lord.
That's what I'm saying.
Lordship, I understand, Lordship. Lordship, but what happened,
We're
Lordship?
fixing it on 18.
18.
Where you records from where?
Lordship, can we fix on?
2015 matter.
Yes, Lordship. Lordship,
This is you have been penalty has been imposed.
Yes, your Lordship.
What the penalty?
Lordship, I was reduced to a lower rank of Nayak for 3 months, and also my sustenance allowance have not been paid.
So you are still working.
No, Lordship, I have retired.
Retired.
Yes, your Lordship.
Then
20 Lordship.
20
December.
or MS learned counsel for the petition. Mr.
J.K. Goswami, additional senior government.
A.K. Goswami,
J.K.
Goswami, learned
additional senior government.
additional senior government advocate, submits that he could not obtain the record as directed by this court on 22/10/2024, for which he prays for further 15 days time to obtain the same for production before this court, for placing before this court, on the placing before this court. Praise the Lord. Let's the matter on 20/12/2024.
Much appreciated.
Issued by Learned Counsel for the petition. The parties list the matter on 20/12/2024, on which that an additional senior government advocate shall produce the report.
Lordship.
आज सुबह के मीटर का टाइम नहीं लक्ष्य
Nothing survived because my lord, against the non-registration of the FIR. FIR was registered on Sasi was filed, my lord. A case was also discharged, my lord.
Discharge. Matter is becoming process.
Yes, my lord.
See, thank you. Heard MS so and so. Learned Counsel for the petition. Mr.
M. Setia, my lord.
M. Setia.
Setia. M.
Setia.
Yes.
Learned Counsel for the Learned what is standing counsel or
Well, my lord, government advocate, my lord.
Learned State Council by placing the communication dated 04/03/2024 submits that matter has become infructuous. Which MS so and so Learned Counsel for the petitioner agreed to. Since the
My lord, I am not only, my lord, on the FIR. My lord, this police officer, my lord, committed much atrocity and damage, my lord, this mobile, computer, printer, etc., my lord.
No, once the investigation, I mean the
Completed, my lord.
investigation is completed and if it's
My lord,
discharged,
there are two cases, my lord. One filed by my complaint, my lord, and another filed by the police himself under section 506. Two cases are there, my lord. My lord, I got from the affidavit in opposition filed by the officer in charge. He mentioned the case registered on my complaint. The officer in charge, my lord, paragraph 7, in their affidavit in opposition.
complaint name is Sanjay Majumdar.
Paragraph 4 and paragraph 7.
No, then you have to file an appeal against
Yes,
the
my lord, against the discharge order, my lord.
discharge. Nothing remains.
Yes.
You are saying first, number one, you are saying that the case has to be registered.
Yes.
For direction to register a case.
My lord, is a PS case. It is a PS case number 54. And here my 54. Yes.
Case was registered.
My lord. And discharged.
Discharged. So
Right.
if you are agree, you have to file an appeal. until the time the discharge stands,
Yes, sir.
with the question of our consideration for
My lord, this
compensation.
police officer also violated, my lord, the direction given in the DK Basu's case.
That is another
My lord,
thing.
That is another issue. Now, initially, first you have to, you said direction for registration of the FIR. FIR was registered. Investigation, charge sheet was filed and discharged. That's all.
It is expected line because police personnel always, my lord, get
Next
my lord.
on the perusal of the next para. Perusal of the communication submitted by the learned State Council from the Superintendent of Police. What is this? Karbi Anglong.
Karbi Anglong, my lord.
Dipu.
Dipu,
Karbi
my lord.
Anglong
My lord,
district.
one case against
Dipu,
me,
just
that
wait.
is, there is no there.
Goes to show that the FIR was registered under section, registered as Hauragat Police Station case number 54 of 2015 under section, yeah. So and so, huh? List of. After the completion of the investigation, a charge sheet was submitted against the officer. Thereafter, the accused has been discharged by the Court of Judicial Magistrate First Class Karbi Anglong on 21/02/2017. Having considered above and considering that the present writ petition has been filed for a direction to register the FIR, for registration of FIR filed by the petitioner. I am of the view that nothing survives in this writ proceeding, in this writ petition. Nothing survives to be determined, adjudicated, in this writ proceedings. Thus, matter has become in process.
My lord, not discharged by judicial magistrate. Can you see, my lord, that order last three line, my lord? The executive magistrate.
My lord, if
It's Karbi Anglong.
yes, my lord.
Karbi Anglong, my lord, judicial.
Anyway, magistrate first
Learned
class.
magistrate, my lord, maybe judicial.
By the Court of Judicial Magistrate.
By the magistrate first class, my lord, it is a judicial
First class
magistrate.
written, my lord, and not judicial magistrate.
Then we'll say by the court of by the court, huh?
By the
Whatever
magistrate
may
first
be.
class, my lord.
See, if you are agreed by the discharge,
Yes,
even not by the competent court, doors are not closed.
yes.
There is a remedy.
No, my lord.
Your case is that your complaint has to be for a direction to your, despite your filing an FIR, they have refused to, they have not registered the case. The case was registered, investigated, charge sheet was filed, and discharged. That's
My
all.
lord, against me, my lord, also
The
false
copy
case
of
is
the
there.
writ petition is still disposed of. According to this, writ petition is still disposed of in process. Copy, next one, copy of the communication dated 04/03/2024. Be kept on record and marked as document X for identification. Marked as document X.
But my prayer, my lord, is also.
What is your prayer?
My lord, against me, that police officer against me, my lord, registered a false case. There is different number, my lord, case number 6 of 2015. My lord, two cases are there, my lord. He first, my lord, lodged a false case against me. And I lodged the FIR. Would I like the FIR that is discharged? My lord, this police officer filed a case against me, my lord. I have prayed for my lord crossing of death affair, my lord. Can you see the charge sheet is also submitted in that case, my lord?
Where it is?
Yes, my lord. To the can you see page, my lord, 25. First class magistrate issue summon against me, my lord. Police officer submitted charge sheet also, my lord, page 25, page 26.
My lord, in that case, my lord, status of death charge sheet, my lord, relating to that investigation.
Because, my lord,
He
I
have to
pray
submit,
for
my lord.
quashing of this, my lord.
This is the charge sheet of 15, my lord.
Not only, my lord,
Trial
torture,
may
my lord,
have
he
also been completed, my lord, in that case also, my lord.
Huh?
Trial may have also completed
No,
in
no,
that
you
case
have to.
also.
in
No,
that
no,
case-
honorable court, stay, my lord. We have first order kindly, you lords, my lord. Honorable court, the honorable court stayed that case, my lord. First order kindly see, my lord. Order dated 2011-2015. Honorable Justice H. Roy, my lord.
One 1545 of 2015. What about this matter?
I'm not aware, my lord, what happened to that matter because, my lord,
Sir, I have
the
no
honorable
impression, my
court
lord.
stay, my lord.
And then cut it. You obtain instruction
Because
by then you just heard Mr. so and so and consent for it. Yes, I
Well,
think you are
well,
right.
if that proceeding has been
See,
stayed, my
there
lord,
is two parts.
Yes, yes,
One
madam.
is for direction for registration of FIR.
That part is
I did
completed.
notice that. That is over.
Yes, ma'am.
It's closed. Right?
Madam, in that,
Second part is,
yes.
second prayer is quashing of the FIR against him,
Yes.
which has been stayed by this court. The proceedings has been
No,
stayed.
not for quashing of the FIR, not for quashing of the charge sheet, my lord. If that charge sheet proceeding has been stayed, my lord, that is still, my lord, pending before the honorable court, my lord. But against the charge sheet filed, my lord, against the charge sheet, he filed this application. Filing of quashing of charge sheet, not against quashing of FIR, my lord.
Yes.
In that-
If FIR will close, charge sheet will go
Yeah, no, my
automatically.
lord.
The charge sheet, have you annexed
Yes.
the charge sheet?
My lord, one charge sheet is there. Yes, page 25, my lord.
In that case, my lord, he has to satisfy, my lord, why, my lord, this charge sheet has to be quashed, my lord.
Certainly, I will feel satisfied because, my lord, so many paper reported this.
So you do until you produce the records of this.
Yes, my lord, that record is to be verified, my lord.
CR case number
Yes, ma'am.
1545 of 2015.
My lord, that is to
Right.
be through
This is
registry,
your
my lord.
case against you.
Yes, yes, ma'am.
I heard Mr. So-and-so learned counsel for the petition. Mr. So-and-so, so-and-so, by placing this so-and-so, huh? Just saying, what do you want to say? By placing the communication with the so-and-so submits that. No, forget it. Submits that, so far as the, right, huh? Submits that, rest you did it, huh? So far as the direction for so far as the prayer for registration of against the respondent number 4, the 7 is concerned. A case was registered being Hauragat Police Station case number 54 of 2015 under section so and so. Same, huh? After completion of the investigation, charge sheet was filed. However, the respondent number 7 has been discharged by the court. Next one. Having considered that the FIR was registered as noted above against the respondent number 5, respondent number 7, and he having been discharged by the court, no issue is decided to be determined. No issue survives so far as this relates to direction for registration of FIR against the respondent number 7. However, the prayer for quashing of complaint case being CR case number 1545 of 2015 under section 510 of IPC against the petitioner.
Executive Magistrate.
No records has been produced.
825.
No record has been produced by the state.
In case
Accordingly, for next for appropriate adjudication as to whether the FIR oblique charge sheet can be set aside, can be quashed. The relevant record would be recorded. Accordingly, the learned state council, Mr. So-and-so,
it should be
is
for a
directed-
registry matter because it is a judicial record is required matter.
accordingly, let the scanned copy of the complaint case being CR case number 1545 of 2015 and this, pending before the court of which court?
My lord, Executive Magistrate, my lord.
Which court?
My lord, Executive Magistrate, first class, Dipu Karbi Alam.
Executive Magistrate first, Exclusive Magistrate, Dipu Karbi Angan. This is the matter after 4 weeks.
4 weeks matter. Can it be for a registry matter?
List the matter after receipt of the case record. Trial court record.
Can the record be called for a registry matter?
Yes, I've said so.
Yes.
Your Lordship, as per the last order, Your Lordship, time was told to file an affidavit, Your Lordship. Accordingly, during the course of the day, Your Lordship, the affidavit will be filed, Your Lordship. Because the brief has been taken away by the client, Your Lordship.
What is the matter?
Matter, I'm not aware, Your Lordship.
Meta regularization, Lordship. He is a master worker, he is paying for regularization, Lordship.
Can it be done at this stage?
So, Lordship, he is, in fact, Lordship, the petition was filed in 2015. And as per record, Lordship, he is 54 years old at that point of time, Lordship. Now he is 63. He already retired in 21. And he is, as per affidavit filed by them, Lordship, today, I have got a copy. It was said that in 22, the brief has been taken back by the petitioner, Lordship. He has not engaged any other, no engagement, Lordship, any other advocate, Lordship, in this case. So he is not interested, maybe, Lordship.
You have filed?
Yes,
Yes,
Your Lordship. But today, during the course of the day, Your Lordship, I will file the
You have filed the affidavit?
Yes, Your Lordship. But during the course of the day, I will file the affidavit, Your Lordship. Not yet filed, Your Lordship.
I will receive a copy.
The copy has been served.
MS so-and-so.
S. Nazneen, Your Lordship. On behalf
S.
of S. Nazneen on behalf of Mr.
K.M.
Bora.
Hassan.
S. Nazneen
S. Nazneen.
on behalf
Nazneen Council appearing on behalf of Mr. K.M. Hassan.
of DC Bora, Your Lordship.
Where is DC Bora?
In the
His name is
cause
here.
list. In the cause list.
Oh,
Your
DC Bora. Learned Council for the petitioner. Learned Council who were appearing for the petitioner submits that in terms of the order dated 19/09/2024. He will be filing the required affidavit as the brief has already been taken from the Learned Council for the petitioner by the Learned Council way back in 2022. Therefore, she pressed for some time. She referred for listing the matter up to 2 weeks, considering that considering the submission of the Council to the petitioner, that the brief has been taken away in 2022, and that thereafter no representation on behalf of the petitioner is shown in the record. Let this matter be listed after 3 weeks.
Your Lordship, the affidavit may come in the record, Your Lordship.
You file it?
Yeah. Your Lordship, received the information already filed, Your Lordship. It will come in the record.
Yes, yes. There is an order that Wakalatnama has not been filed.
It has been filed now.
It's been filed. No, it's a technical, otherwise, no issue. Cannot debar you.
My lord, this is second round.
Yes.
Now we are coming for Lordship. Well, this page 35, your Lordship can see.
Page 35. Yes.
An inspection of the electric connection meter was done. And Lordship find the general remarks and observations.
Yes.
A routine inspection was done on the consumer's premises, and on inspection, it is found that the paper seal of both sides meter bearing number so and so found cut and refixed with glue. So the meter is opened in presence of the consumer and found local soldering spot on CTS secondary terminals on PCB, and also steel plate covering CTs secondary on PCB is found missing. So the team considered it fit case for tempering of the energy meter. Your Lordship kindly note. Tempering of the energy meter. The area manager so-and-so is required to do necessary action as per judicial norms. The CPT state cannot be checked, as the subdivisional officers cannot provide the ladder because they are busy in restoring power supply so-and-so.
Yes.
Now, thereafter, my lord, you also find.
Yes.
A notice was issued to us at page 39 to appear for statement, and thereafter, my lord, a complaint was also filed in the officer in charge before the police station, and at page, my lord, 41, we submitted the reply also to the office in charge of the police station. Then at page 43,
yes,
we submitted a reply to the area manager, Dibrugarh Industrial Revenue Collection Center, and I will take a loss to only some of the paragraphs below.
Yes.
At page 45.
Yes.
In the middle, my lord.
Yes.
Now, under the provision section 126(3) of the Electricity Act, I so-and-so, on behalf of so-and-so submit as fact. The energy meter number so-and-so lying to the distribution subdivision in the official premises was inside the double compartments metallic enclosure, having seals on the openings of the metallic enclosures. The seals were found intact on 12th April 2017. The outside seal, which was there, that was found intact on 12th of April 2017. So there is no scope to temper or causing damage to the energy meter number so-and-so without breaking the seals on the body of the battery meter enclosure. From time to time, officials of the APDCL broke and replaced the seals provided on the energy meter enclosure for extracting data from the energy meter
using meter reading instruments without preserving consumers' representative. The last sealing was done on 7 January 2017. The outside meter seal was put by the judicial. That was found intact. Now for taking the reading and all inspecting the inside meter, they come, they break it, they again take the meter readings, etc. by any inspection, and then again they seal it and put the outside seal, which was found to be intact. It was not found to be below any tampering. As per the meter seal records of APDCL, the seals affixed over the material litter cabinet enclosures were broken by the APDCL official on 6/8/2014, 4/9/2014, 12/1/2016, 16/2016, 7/3/2016, 8/4/2016, so and so, and lastly on 7/1/2017, and the cabinet box seals were replaced by the new and fresh seals on aforesaid dates. No anomaly was noticed or found on such aforesaid dates by the visiting APDCL. It is not known how any assessment bill can be raised for the period of 12 months. Altogether, seals were found intact on the date of inspection and prior to the inspection at least 2 years. It was said that for the period when the seals were found to be intact and there was no tampering was found at the time of inspection, the question of raising the bill for that period does not arise. Your Lordship may skip over and come to page 47. Whereas 10, my lord.
Yes.
The assessment, if any, for any authorized use of electricity has to be made as per the provision contained in section 126(1), read with section 126(5) and 126(6) of the Electricity Act. That the condition precedent for making assessment in section 126 is that the assessing officer is required to reach a conclusion finding to the effect that on the date of inspection, the consumer was found indulging in unauthorized use of electricity. Your Lordship may kindly note it below. He must come to a conclusion on the date of inspection that the consumer was engaged in the unauthorized use of electricity. And the assessing officer is further required to make base judgment assessment of the behalf of so-and-so consumer. Now, my lord, after that, the final bill was raised on me, which you'll also find page 51, in spite of my objections. Now, I approach this honorable court.
50.
My lord, 51. Page 51, my lord.
Final bill.
Final bill was raised.
This page 49 is?
Well, page 49 is the order which your lordship, I will take your lordship to the relevant part. This was an appeal which was filed. And lordship may see page 50.
Yes.
A statement of so and so. And thereafter, my lord, so from the above, it is seen that the TC report dated so and so after checking the monitoring installation of so and so is found to be correct. So assessment bill of rupees so and so, and towards reviewing of assessment bill of rupees so and so, assessment bill, it cannot be acceded that any anomalies could be detected after taking the meter from the cabinet is not done during the meter reading, collection and the downloading. Tampering of the meter of Ganpati was confirmed. You are also noted. Tampering of the meter of so and so was ascertained. No exemption can be granted. So they said tampering of the meter was ascertained. Now 126(1), my lord, the satisfaction has to be arrived at that the consumer was engaged in unauthorized use of electricity. That is the precondition for section 126(1). Now, being aggrieved, we challenged it before this honorable court, and with this honorable court, remanded the matter back. You also see page. It starts with page 52,
55,
and 65. 52 it starts, and 65. Para 30.
This is writ petition.
My lord, the writ petition judgment was delivered below.
This is Rajshri T.
My lord, this is my name is also there below. You will also find. at page 52, no, my lord, prior to that.
Okay, 56.
56, my name is there, my lord.
Yes.
And at
Ganpati.
page 65.
No, it's here it's page 55.
I'm sorry, my lord.
Start from page 55.
Internal page of the judgment 11, my lord.
Okay. Common judgment.
Common judgment.
Page 11.
Page 11,
Yes.
internal page 11, my lord, para 30. As you also got it, my lord.
Yes.
May I read, my lord, this important paragraph, my lord?
Yes.
On a thorough consideration of the matter, in the considered opinion of the court, the final assessment order bill so framed cannot be sustained in law for the simple reason that there is no finding prima facie or otherwise that there was unauthorized use of electricity by the petitioner as provided in explanation B to section 126 of the Act of 2003. So, my lord, the court held, my lord, that the final assessment bill cannot be sustained because there was no prima facie finding that there was any unauthorized use of electricity. Recording of any finding at the finding that there was unauthorized use of electricity by the concerned person is a condition precedent for invoking jurisdiction under section 2126 of the Act of 2003. In the absence of such a finding, the final assessment would stand vitiated because the assessing officer would stand divested of his jurisdiction if it is not a case of unauthorized use of electricity. That apart, at the time of passing the final assessment order under section 126 of the Act, reasonable opportunity or so and so, it is to be given. That is, I am not concerned with that. Similarly, the court came to finding, while setting aside the assessment bill, that there was no prima facie finding that there was any unauthorized use of electricity.
Yeah.
Now, my lord, there is also distinction between section 126 and 135 of the Act, which you'll also find at page 27, there are 27, internal page 9, my lord.
Yes.
Has you also got it, my lord?
Yes.
Dealing with the scope of the ambit of section 126 of the Act and the distinction between section 126 and 135 of the Act, a three-judges bench of the Supreme Court so has held that there are marked differences in the contents of section 126 and 135 of the 2003 Act. They are distinct and different provisions which operate in different fields, have no common premises in law. While section 135 deals with the theft of electricity, which is a punishable offense, section 126 would be applicable in cases where there is no theft of electricity, but the electricity is consumed in violation of the terms and conditions of supply, leading to malpractices, which may fall within the sweep of the expression unauthorized use of electricity. While section 135 squarely falls within the dimensions of criminal jurisprudence, there may be one of the relevant factors for determining the case of theft. Section 126 does not speak of the criminal intent and a primarily civil action. It does not have the features and elements which are traceable to a criminal concept of the mens rea. Pausing here for the moment, from a careful analysis of the provision section 126 vis-a-vis 135 of the Act, as held by the Supreme Court, what is reducible is that both section 126 and 135 are in contradiction to each other. Section 126 of the Act of 2003 would be applicable in cases where there is no theft of electricity, but electricity is being consumed in an unauthorized manner, but where there is dishonest and theft of electricity, section 135 would come into play. Therefore, proceeding initiated in section 135 and a proceeding under section 136 on the same grounds may not be legally sustainable. Now, in this case, my lord, the action was taken under section 135 of the Act, and a criminal case was also filed, and the criminal case has been dropped that because of the lack of evidence and all those things, the benefit of doubt has to go to the consumer, and thereafter the criminal case was dropped. Now, 126 when the assessment, when you proceed with the 135 for theft of electricity, side by side you cannot proceed with section 126 of the Act. As the Supreme Court has said, my lord, the 135 and 126 are two different things. 135 is a criminal one, theft, where you can initiate the criminal proceedings and the assessment is to be done. 126 is there where the finding theft is not there, but unauthorized use of electricity is there. Now, this honorable court specifically held that the assessment bills are to be set aside on the ground. There was no prima facie finding by the authority that there was any unauthorized use of electricity. Now, after this remanding back of the matter, my lord,
What is your case in this matter?
well, again the bill has been raised and there is no finding.
No. Ganpati is 2992. There are different directions.
My lord?
They are different directions.
The direction in the case of my lord, common to all, my lord.
The final 2992 cannot be sustained. Okay. Yes.
All assessment bills were passed and the objections were raised, to be raised.
Yes.
Now, a lawsuit can see again at page 67. After the remanding back, my lord.
Yes.
What is the finding? At page 68, you lost
This is the impugned order.
Impugned order, my lord. After that, the bill has been raised. At page 68, my lord.
Yes.
Statement of apudicial personnel. So-and-so duplicate qualified during inspection of so-and-so in presence of the consumer representative. It was found that the paper seals on both the sides of so-and-so were cut and refixed with glue. Also found that the seal considered sports of city conduits terminal on so-and-so. That is, I read, my lord, in the inspection report. That was the prior one, my lord. Objection regarding intimation during meter reading and share was denied by the so-and-so. He stated that so-and-so, a consumer representative, every month appears and present during the visit. Considering the above facts, it is observed that though the meter outer seal of meter cabinet remained intact, your lordship can note in, he is admitting, my lord, that the outer seal of the meter was intact during inspection. Nevertheless, it is fact the paper seals of the meter find cut on both sides and local sports of city screening terminals in SV and missing of steel plates covering so-and-so is a interference of the metering system. So hearing the point raised by both the sides, it is clear that the consumer was indulged in malpractices. Now, the same thing was done, my lord, observed in the earlier order also, which was set aside by this honorable court, and the same thing, my lord, is observed here also, that the malpractice. I will show to you, lordship, that they mention malpractices. Now, lordship, can you see further, my lord? Now, the question is quantum of energy loss by epidicial due to indulgence of malpractices done by the consumer. After analysis of the consumption pattern of the consumer, it is not possible to determine the quantum of energy loss by the epidicial. Now, they say, my lord, that it is not possible to determine the energy loss by the epidicial. The statement of the wheat purchase submitted by the consumer was not authentic. One to consider it as there is no unit of wheat as well as missing of or sign of any government. But I was a flour mill, so I submitted the details of the wheat which was purchased for grinding, so that they may determine that what may be the unit consumption of that one. Okay. Now they say that this is not sufficient.
That's why I was about to ask you, what does it wheat and purchase?
My lord.
Yes.
After studying with the consumption of consumer of same type under duplicate electrical, it is observed that during the month of November 16, the production was very low, probably due to demonetization, whereas consumption of Mr. So-and-so was more than normal on that month. In view of this, undersigned decides to intake the provisional bill. Now, my lord, your lordship, can you see?
Assumption and presumption.
Presumption, and there is no finding. Your lordship, see earlier also order in the High Court order, my lord. What was the finding? Your Lordship may kindly see, my Lord, at page 65.
Yes.
The quotation, my Lord, statement of the personal, my Lord, it is there. Thereafter, last paragraph, my Lord. From the above, it is seen that the consumer adopted malpractices by tampering of the energy meter number so and so. At page 65.
Yes.
Now, in the earlier finding also, they have said that the consumer has done malpractices by tampering of the meter. And this honorable court came to a conclusion that there was no finding, prima facie finding that there was unauthorized use of electricity. And without that finding, the 127 below the power cannot be invoked. And on that ground, the bill was set aside and matter was remanded back.
Yes.
Now again, in this, after remanding back, the officer is saying the same thing. He had not come to a finding that there was unauthorized use of electricity. In fact, he is saying that the loss cannot be determined. It's not possible.
Yes.
When this honorable court has come to a finding that 126(1) power cannot be exercised without coming to a finding that there was unauthorized use of electricity, whereas in the earlier part order also it was said that there was malpractices. Then again in the final order again, on the same ground of malpractices, you know, how the final bill can be raised?
There's no appeal.
You know,
you have not preferred appeal.
I have not preferred an appeal because, my Lord, I already came earlier. There was judgment, the direction was there, and the direction has not been followed. When any direction given by the court is not followed,
Then you could have agitated this before the appellate authority.
well, yes, certainly, I could have agitated. But your Lordship is aware, my Lord, alternate maybe when the court has passed an order, giving that this is a precondition for invoking the jurisdiction as 126(1), and somebody invoked that is without jurisdiction. If I could have come, my Lord, before the judgment of this honorable court, then one could have said that you could have invoked the jurisdiction under appeal authority. This honorable court has laid down specifically that these are the preconditions and has set aside the assessment bill. Now, second round, again the same thing. Somebody is saying.
Therefore, the appeal would be a mere formality.
My Lord, you also may just see.
Appeal would be a mere formality.
Otherwise, my Lord, what will happen? A court keeps a judgment on a particular facts, keeps a law, and somebody passes the same order and says that you go in appeal.
So appeal would be an appeal from Caesar to Caesar's wife.
My Lord, appeal, I normal course, my Lord, I fully appreciate your Lordship, my Lord, that appeal has to be filed. But whether it is not a case of absolutely without jurisdiction, the order of the authority, and also going against the decision of this honorable court. He has ignored totally the finding of this honorable court. Some person, sane person at least, my Lord, could have passed the order by observing whatever has been observed. He could have written there that there was an unauthorized use of electricity and all those things. They have not cared also to see the judgment. Otherwise, any authority, my Lord, by going through the judgment, would at least write few lines that there was an unauthorized use of electricity, all those things. They have not cared. They simply pass an order, writing the same thing. How such an order can be sustainable in view of the clear law laid down by this honorable court? Malpractices was earlier also mentioned. Now also they have mentioned malpractices. Loss of revenue, they say that it is not possible to determine. consumption of wheat, they said, no, we cannot take into consideration. Then what factors you take into consideration?
So after analysis of the consumption pattern of consumer, it is not possible to determine the quantum energy lost by APDSL. Then what the question of final?
Then how you are
how
getting bill to me?
Final bill is assessed?
Unless and until you come to conclusion there was a loss. How you can raise a bill on me?
It's like a simple penalty of malpractice.
Not penalty, my lord, because we have gone inspection, we have to do it. First of all, he must come to a conclusion there was an unauthorized use of electricity, and because of that, there was a loss to the electricity board. You have not fulfilled the first condition, unauthorized use of electricity. Secondly, you are saying that it is not possible. If it is not possible, can you impose the burden on me? And you say that in November, perhaps you got demutation.
No, that is why I'm agreeing that if it's not possible to find out the assess it for the energy loss, how the penalty.
And we also see in November, probably due to demonetization, the production was less. Now, my lord, your lordship, just see, my lord, because of demonetization, can be production will not be less. What is the demonetization? Some cash.
It's just simply an assumption.
But demonetization has not affected the industries. Wheat, whether demonetization is there or not, people will consume the same thing. Whether the demonetization has affected the consumers of wheat, whether they have stopped eating the rice and wheat, my lord, atta. My lord, what is type of finding, my lord, this? My lord, this is my short submission for lordship.
May I please, my lord?
Yes.
Firstly, my lord, we've raised a preliminary issue with regard to the maintainability of the writ petition, my lord. There is a judgment of a coordinate bench, my lord, which was again upheld by the Honorable Division Bench. My lord, my learned senior had appeared in that matter.
Yes.
My lord, I'll pass a copy of the
maintainability. Why?
Well, because there is a appellate provision, my lord. There is an appellate authority, and the Honorable Single Judge and the Division Bench have clearly held that without availing the remedy before the appellate authority, a writ petition challenging the final assessment and the proceedings leading up to the final assessment cannot be challenged, my lord.
No, that was in a simple matter where there's no.
There's
no observation by the court. You could have a different finding. It's more or less same finding which has been set aside. That is the problem. That's
issue,
why he said
yes, madam.
Appeal would be amount to an appeal from Caesar to Caesar's wife.
Follows the appeal, the provision of an appeal.
Empty formality.
It perhaps is not, because, my lord, the Honorable Division Bench goes on to say that whether or not the due process under 126, which is the assessment, whether or not that has been done, that is within the scope of the appellate authority under 127, my lord. That observation may kindly be read, my lord. That judgment in writ appeal number 286 2021, 2021, my lord. Para 9. Categorical finding, my lords. Para 9 of the Division Bench judgment, my lords. Yes, my lord. Shiva laws. Para 9, my lords. After considering the rival submissions of the parties, we are. My lord, has that?
Yes.
Para 9, my lords. After considering the rival submissions of the parties, we are of the opinion that presently the remedy available to the writ petitioner appellant is an appeal under 127 of the Electricity Act, where he will have a liberty to place all his points, including whether due process under section 126 has been adopted or not, and whether quantum of assessment is in order. As a statutory remedy of appeal is provided to the writ petitioner, we are in agreement with the opinion of the single judge that the writ petitioner should approach the appellate authority first for redressal of his grievance.
I think that is elementary.
Yes, my lord. That without that, the appeal, my lords, being preferred under 127, a writ petition, my lords, is not maintainable, my lords. We have taken a categorical objection in our affidavit in opposition. No reply has been filed, my lords.
Legal issue, no reply.
We'll consider. Then On merit?
On merits, my lords. On the issue as to whether or not the assessment is in order, my lords, because the submission that was put forward is that the quantum could not be assessed. I was may kindly have the Electricity Act, my lords. And if my lords is dealing with the issue of the appeal, my lords, I'll crave indulgence, my lords, to read the judgment of the learned single judge, my lord, because a lot of issues have been decided that would have a direct bearing on this case also, my lord.
Which one?
The judgment that I just passed, my lord, the judgment of the learned single judge, my lords.
Single judge is of what?
Yes, my lord. Single judges.
Recorded in GLR.
Yes, my lord. The one in GLR, my lord.
And which you have read it
Is the division bench upholding the judgment of the single judge?
Against me, I appeal, no?
Yes.
civil lawyers.
So this is 2021 4 GLR 558, my lords.
Yes.
My lords, the para 3 of the judgment, para 3 of the single judge's judgment, my lords.
No, you said this thing, Electricity Act.
No, my lords, the judgment, if my lord takes up the judgment first, my lords.
In civil lawyers?
In civil lawyers, my lords. The
Yes.
learned single judge, my lord.
Hmm.
Para 3, my lords, again a preliminary objection with regard to the maintainability of the writ petition is raised. Now, my lords, at para 7, para 7, my
This was the assessing officer has come to the finding in this letter clearly that there was an unauthorized use of electricity and the theft.
yes, my lord. Even here, my lords,
Yeah, in the present case, it simply says malpractice.
malpractice, unauthorized usage, my lords, the judgment will make it clear, my lords. If I can read further. My lords, para 7, certain issues are called out, my lords. 7, yes, my lord. 7B, whether section 127 of the Act covers under its sweep the final order of assessment on the basis of the provisional bill under section 126(1) of the Act of 2003 against unauthorized use of electricity on the allegation of theft of electricity falling under 135, which is again is the same case here, my lord. There is a criminal case under 135 which has also been filed, my lord. Now, that instruction I do not have, my lord.
I have got the copy.
Very well, my lord. But that has no bearing, my lord. These are separate proceedings altogether. Now, issue number C, my lords. Whether considering the factual matrix, this writ petition is maintainable, my lords.
Where it is?
7C, my lords.
Where is the finding?
Yes, my lords. Para 19, my lords. The learned single judge refers to a decision of the Honorable Supreme Court in Southco, my lords.
Yes.
Para 19, my lords.
Hmm.
17 of the Southco judgment is quoted, my lords. all instances of unauthorized use of energy may not amount to theft of electricity within the meaning of Section 135 of the Act. But at the same time, the theft of electricity, which is covered by Section 135 1A of the Act, without prejudice to the other provisions of the Act, the licensee or supplier, as the case may be, upon detection of, is empowered to disconnect so and so, my lord. Now, thus it is clear the authorities under the Act are empowered to make a provisional and final assessment by invoking powers under Section 126(1) of the Act, even when cases where electricity is unauthorizedly used by way of theft. When a consumer so and so, then the procedure is called out, my lords. Then under, my lords, issue number B starts from para 23, my lords.
Come to para 26. If the jurisdictional issues are raised,
No, where, my lords, respectfully, no jurisdictional issue. There is no pleading, no whisper to that effect, my lords. My lords I have gone through the writ petition. They have not filed a affidavit in reply. They have not raised the issue of jurisdiction, and a technical issue is being raised at this point in time, my lords. They have not pleaded that. That is not their pleaded case.
that's all.
And also, my lords, para 27, my lords will kindly read further,
Yes.
my lords.
I've read it.
Yes, my lord. Para 28.
I've read it.
Yes, my lord.
I've read everything.
Yes. And as far as the quantum not being assessed and that energy loss could not be determined, my lord,
Yes.
Electricity Act may kindly be seen, my lord. Section 126,
Yes.
the assessment, my lords. The procedure is laid down, my lords.
Hmm.
126 5, my lord, subsection 5. This is how the assessment or the quantum has to be ascertained, my lord. If the assessing officer reaches to the conclusion that unauthorized usage of electricity has taken place, the assessment shall be made for the entire period during which such unauthorized use of electricity has taken place. And if, however, the period during which such unauthorized use of electricity has taken place cannot be ascertained, such period shall be limited to a period of 12 months immediately preceding the date of inspection. That is, it is not that if the period cannot be ascertained, we are not at liberty or we are not empowered to raise a or impose a penalty. That assessment, however, has to be limited to 12 months from preceding the date of inspection, my lord.
That has been set aside, and you are upholding it again.
That has not been set aside, my lord. What was set aside was, respectfully, subject to what Lordship says, my lord. Initially, the
Just
order.
read the judgment. Last time.
My lord.
Single bench judgment.
Oh, sorry.
final assessment orders that is so and so in red petition.
Yes, my lord.
We are concerned with 2992. Huh?
Yes, my lord.
Page 66. Cannot be sustained. Those are according to matters to reconsider objections raised by the petitioner.
Keeping in mind
the discussion made in
Yes.
earlier. Yes. Then you said the bill assessment, the final assessment bill amounting to is served to the consumer for payment. No. This is the final thing after the judgment. In
Because
they said to intake the provisional bill already served to the consumer.
Yes, because my lords will appreciate initially when the provisional assessment was done, my lords.
Where is the provisional bill?
37, my lords.
For 12 months.
No,
Is it for 12 months?
no, it was not for 12 months. It was reduced by the appellate authority to a period of 12 months. By the assessing officer, my lords, I'm sorry.
For 12 months.
It was reduced to 12 months upon their
Where it
objections
is, where
being
it
filed.
is.
Yes.
Page 49. As provisional bill amounting to so and so already served is revised to so and so may be treated as final.
The provisional assessment at page 44, my lords will see the initial assessment was to the tune of 75,90,730, my lords.
For how many months? For entire period.
Yes, for the entire period.
Then come to page 50.
Yes, it was then the assessing officer had reduced the amount and directed that the period be reascertained, my lords. The amount be reascertained. So it was then reduced to 65 lakhs.
How?
By taking the period as 12 months. Because
Where
the
it is?
period,
Where it is?
no, that will not, is not reflected. I'll produce the records if that is necessary, my lords. I'll produce the records. It will have photographs, it will have videos and everything of the inspection and everything. Those were placed before the.
Listed for hearing. Why you are the producer?
My lords, because there was an issue with regard to the maintainability, my lord. So deems fit, I'll produce the records, my lord.
No, we will consider all. What is possible?
Let me produce the records, my lord, because at the end of the day, my lord, this is a public revenue, my lord. We are an energy deficient state, my lord. We are losing
You
electricity.
have to tell.
My
We are
lord.
conscious of that.
My lord, I'm
Here
deeply
the
aware.
records may not do. There is a direction of the Nani single judge that has attained finality, that has not been challenged. A finding has been arrived at that precondition for 126(1) is that a finding must be arrived at that there is unauthorized use of electricity. On that ground, the bills were set aside. Same without again the admin order passed without any finding that there was unauthorized use of electricity. The calculation part will come subsequent to first to fulfill the part. My another friend also said that there is not a pleading that there is a jurisdictional issue. You will see Glossy pair 30.
My lords will allow me to produce the
Pair
records.
30,
That will be
and
relevant, my lord.
This court is not sitting in the rich court, and there is a judgment of this on the court already. Pair 30, Miller. At page 29. The petitioner states that ordinarily against the final assessment bill, the statutory appeal provided someone to initiate the act, but as the petitioner assumes the very jurisdiction of the assessing officer to undertake the provision of final assessment bill, in the case of project against the petitioner, neither assessment nor so. So my friend says that no, they have not uttered a single word.
My lords, we kindly read further, my lords. Presently, there is no appellate authority that is.
That is a second ground. We take a number of grounds, my lord. And as you lordship aware, my lord,
When you file this writ petition, there is no residing
at that time. So, my lord, the question that the jurisdictional issue has been raised, that is there.
Yes.
And your lordship may kindly appreciate, my lord, whenever your lordship, this honorable court gives a finding and judgment which has attained finality, then the authorities who are directed to reassess or make a, my lord, give a finding has to be in terms of the judgment of this honorable court. And if they flout the orders and pass against the order, my lord, that assessor cannot be directed at go in appeal. And simply because the APDCL is suffering loss, can, my lord, the SSC be burdened with the liability which is the liability cannot be there at all.
So can the appellate authority not gone into the points which have canvassed?
You know, the only point is that whether the
Taking into the referring to the Lawrence single
precondition has been fulfilled or not. You will also will examine the order which is there, whether it has been fulfilled or not. If it has not been fulfilled, the order is liable to be set aside. Lord, you will also may kindly examine whether the Lawrence single judge has held with this is a precondition, and without fulfillment of this precondition, power under section 26(1) cannot be exercised. Now you will also read the order whether the same preconditions have been fulfilled or not. And 135, my lord, you will also kindly see, the single judge also said 135 and 126 are different proceedings. They initiated the proceeding under 135. Ultimately, when the matter was there, they have withdrawn it because of some religions. Now, on the one hand, they are saying that we are proceeding 135. Then they are saying that we are proceeding on 126. For 135 also, you can make a provisional assessment under section 126. But after having filed the case under 135, you withdraw it. And thereafter you say 126. And 126 also the preconditions have not been fulfilled. And nobody can, my lord, fetter the powers, compute fetters on the powers of your lordship, my lord. This is a self-imposed restriction. Lordship is not going to see the video and all those things that how it was done. The lordship will go only with the pleadings and papers.
Allow me, the withdrawal of my lords.
I am not going into it.
My lords, if I may be allowed to submit, my lords. 126, my lords. The idea behind section 126 is to recompense the licensing authority for the loss that they may have incurred due to the illegal act of malpractice and unauthorized use of electricity. And for the commission of that offense, the provision is under 135. That is the criminal proceeding. So there is no interconnection as such, my lord.
Right.
That loss, if I may just submit, my lord, that 126 proceedings, the assessment done under 126 and whatever happened to the proceedings under 135 have no bearing. And that withdrawal, my lords, is in terms of a notification issued by the state government when it says that for offences where the period had been reduced to 2 or 3 years punishment, all offences were blanket with a blanket order withdrawn, my lord. That with the APDCL had not withdrawn that order. And if I may also be allowed to produce the records, they'll be relevant, my lord, because the records were placed before the authority.
You could have bring it today.
My lords, that is there is a mistake on my part. My lord, I'll produce it, my lord. That is relevant, my lords.
According to me, the lordship.
Oh, they will.
I'm submitting. The Lawrence single judge, by reproducing the order, my lord, of the authorities, I came to finding, as you lordship, my lord, that whatever are there in the order, in the passing of the order, that cannot be improved by something else. If there were no malpractices, no unauthorized use of electricity, can somebody say now that there was unauthorized use of electricity? That will will examine only from the order. No, somebody cannot improve it.
Videography, if it is shown that there was a theft or unauthorized use, even if you have not, when the assessing officer doesn't disclose it in order, can we say that no, in the videography there is a theft?
My lords,
we find that there is a theft or unauthorized use.
What happens essentially?
One the single milord that
yes.
The old wine milord cannot.
I've understood. I'll consider everything.
My lords, only final submission, my lords. I'm deeply apologetic, my lords. What happens is, my lords, when the final assessment is passed, when the objections are filed and the matter is heard by the assessing officer, which the order impugned, my lords, the inspection report, the photographs, the inspection of the meter report and everything, which were signed and countersigned by the petitioner also, my lord, they are all taken into account. Those documents and everything are also a basis of finding the order, of issuing the order.
I am also saying so, my lord.
Yes.
After considering that, he
So
has not,
those records, if my lord,
he cannot come to finding that.
give me the liberty, I'll produce those, my lords.
It's okay.
I'm highly obliged, my lord.
Heard Mr. Yes, sir. senior counsel assisted by
PK Bora.
learned counsel for the petition and
B. Chaudhary, my lord.
B. Chaudhary, standing counsel,
My lords.
APDC, for all the respondents.
My lords, all the yes, my lords, all the response.
Hearing concluded.
It was a pleasure
Judgment pleasure.
arguing before Lordship, first time sitting singly and it has refreshed the past memories, my lord.
Equally, it's my privilege.
I am grateful to your Lordship.
My lords, may I take the liberty of filing a written argument, my lords? if I say?
What's the? Have you not filed the?
There is an affidavit, my lords, a small written argument, my lords.
Do you have doubt on this?
No, my lords, for my satisfaction only, my lords.
I don't need, my lord, any written submissions. I have,
My lords.
my lord, whatever your Lordship has understood, my lord, I am fully satisfied, my lord, that I'm grateful to your Lordship.
Deeply obliged.
Affidavit in opposition in the matter. I've taken up two preliminary objections, ma'am. Ma'am, probably she'll have to address those two issues first on the maintainability of the writ petition. Number one, my objection is that, my lord, since the petitioner is a company, there has to be a board resolution of the board of directors of the company authorizing the petitioner to file the writ petition and also to swear the affidavit. Without that, this writ petition is not maintainable. Secondly, there is statutory remedy provided under the Railway Claims Tribunal Act, my lord, to the petitioners to agitate their grievance. Now, bypassing that statutory remedy, my lord, they cannot approach this honorable court. Now, since it is a company, my lord, there is no resolution of the board of directors deciding to file the writ petition before this honorable court, and also there is no resolution authorizing the petitioner to swear the affidavit in the writ petition, my lord. And even after giving them ample chance, my lord, they have not rectified that defect. In fact, in their affidavit in reply, they have stated that it is not required, my lord. This is absolutely absurd.
Lordship, I will reply to his preliminary objection. First of all, Lordship, I would like to place some facts of this case, Lordship. In this case, Lordship, the petitioner have challenging the DC bill statements issued by the respondent number 5, that is Lordship Chief Goods Superintendent Salchapara, and impugned letter dated 22/11/2021 issued by the respondent number 4, that is the Divisional Railway Manager Lamding. So these two impugned letters, Lordship, will find at page, that is Annexure 1, 2 and 3, Lordship will find at page 25, 26 and 27. So this Annexure 1, 25 is a, Lordship, DC bill statement, which means damage charge bill, Lordship. They have imposed total 7,14,420, Lordship, for the detention of railway wagons. So, Lordship, in this case, we have loaded 11,642 drums of bitumen, Lordship, from Haldia Dock Complex to Salchapara. And, Lordship, this consignment was entrusted to railways on 9th of September 2021, Lordship. And the same was arrived on 14th of September, Lordship. So here this statement was given, Lordship, and entire thing is there, Lordship. So the railway allegation is, since we have not unloaded the consignment within the prescribed free time, Lordship, so they have levied penal demurrage charge. So the definition of demurrage charge is given, Lordship, in the Railways Act 1989 under section 211, Lordship, which says, Lordship, demurrage charge. Lordship may kindly see the definition of the demurrage. Lordship, here the definition of damage is given in the Railways Act 1989 in 2 subsection 11, Lordship. Here the definition says
Section
211.
211.
No, 2/11, subsection 11 of the Railways Act 1989, which says, Lordship, damage means the charge levied for the detention of any rolling stock after the expiry of free time, if any, allowed for such detention. Here the permissible free time is, Lordship, 9 hours. So if we unload the consignment within the period of 9 hours, Lordship, then no damage charge will be levied. But beyond that, the railway has the power to levy damage charges. But here, Lordship, the question is, whether this levy of penal damage charge is legal in the eye of law or not, Lordship. Here, our grievance is, Lordship, the levy of penal damage is, Lordship, against the principles, guidelines issued by the Railway Board, Lordship. Here, the preconditions were not fulfilled by the railways. There are two essential conditions, Lordship, which needs to be fulfilled before levy of penal damage charges. And the first condition is, Lordship, they have to give 48-hour due notice before levy of penal damage charge. Second, Lordship, wide publicity. So these two
What is the
important,
requirement of 48 hours?
Lordship, it is there in the Railway Board circular dated 19/5/2016, which I have annexed in my affidavit, additional affidavit, Lordship. Lordship, may
You
kindly
request 48 hours.
48 hours due notice, yes, Lordship,
Then
and wide publicity. And the same circular I have annexed, Lordship, in my additional affidavit, Lordship will find at page 85.
okay.
So, Lordship, as per para 3.4, Lordship, here the condition is, Lordship, if permit me, Lordship, I can read the paragraph, Lordship.
3.5.
3.4.
It is circular 19/5/2015.
19/5/2016.
Page
Lordship, 85. The relevant portion is at page 85.
running.
No, additional affidavit. In my additional affidavit.
You have additional file in affidavit.
Lordship, there is a direction of this honorable court to Lordship address some issues so far as the learned counsel for the respondent has raised during that time, Lordship. So, in compliance of that order, Lordship,
85 is something different. Which 85?
page 85, Lordship.
Okay.
In continuation to my writ petition, Lordship, another affidavit I have filed, Lordship. Page 85. 29 is also there, Lordship.
In my affidavit in opposition also I have annexed it.
29.
I don't know why there are two numbers, two paginations.
I have seen that record, Lordship. There are two paginations, yes, Lordship. 85 as well as 29.
In my affidavit in opposition, my lord, if they,
85. The operating part is at page 73. The circular is start from 73 and the main relevant paragraph is at page 85. Lordship, para 3.4, panel damage charge. Lordship, got it?
Yes.
So here, Lordship, the guideline says that in case excessive congestion takes place at any terminal steel plant, CCM, COM, DRM can increase the damage rates even at progressively increasing rates subject to a maximum of 6 times of the prevalent rate. This panel damage rate should be implemented only after giving wide publicity and due notice of 48 hours and should be applicable for the notified period. The rates can be increased by say 2 times or 3 times or so on and not necessarily 6 times at one go in all cases. In fact, railway may decide to levy variable rates like 2 times for first 3 hours detention, 3 times for next 12 hours detention and so on and so forth. Railway must judicially evaluate the situation and the rate should be increased on merit to the extent considered justified. Levy of 6 times rate should be resorted only when the situation becomes very alarming. So in terms of 3.4.1 paragraph, Lordship, here panel damage charge will be implemented only if there is a wide publicity or, Lordship, and due notice of 48 hours notice must be served to the party, Lordship. In my case, Lordship, both the conditions were not fulfilled by the respondent railway authorities, Lordship. So my grievance is, Lordship, since they have not fulfilled these two conditions, important conditions, so the levy of panel damage charge is illegal, Lordship. Second point is, Lordship, here this entire thing was done, Lordship, during the period of second wave of Corona, Lordship. At that point of time, Lordship, Lordship were very aware of that position, Lordship, because of that situation, Lordship, laborers were not available, Lordship, to unload the consignments. And there is a guideline of the Assam state government, Lordship, which I have annexed in my writ petition, Lordship. May kindly see that document, Lordship. Lordship, it is there at page 49 to 54. This is the circular notification issued by the Assam State Disaster Management Authority, Lordship.
Page
49. First September 2021 is the order date issued by the government of Assam State Disaster Management Authority. Here, Lordship, some restrictions were imposed for all the districts to follow the protocol, Lordship. Here, the curfew time was given, Lordship, page 50, Lordship. May kindly turn to page 50. Page 50 is relevant, Lordship. Here, restrictions were given, Lordship. Here, the curfew time was imposed, which was in force from 9 p.m. to 5 a.m., Lordship. So, Lordship, partial curfew was there, Lordship, and our our consignment was placed at, Lordship, 7:40 in the evening, Lordship, 1940, that is, Lordship. So, beyond that, Lordship, laborers were not available, and, Lordship, as per this order of the Assam government, Lordship, only 50 persons are allowed, Lordship, at that time, Lordship. Gatherings are very limited, Lordship. So, for unloading the consignment from 42 wagons is not an easy job, Lordship. So, we need around 200 to 300 laborers, not 200 only, Lordship can say 100, minimum 100 laborers were required, Lordship. And here, in this case, Lordship, we found it very difficult to manage laborers, Lordship. Truck drivers were also not available. So because of that reason also, Lordship, our consignment was not unloaded on time, Lordship. But, Lordship, we have also made a representation to the respondent, Lordship. Lordship, may kindly turn to page, Lordship. Our representation letter dated is 16/9/2021, Lordship. It is at page 44, Lordship. We have made a representation and we have elaborately, Lordship, stated our grievances. And, Lordship, may kindly turn to page 44, Lordship. Annexure 11. This is the first letter, Lordship, I have issued to the Divisional Railway Manager, NF Railway, Lamding. That is respondent number 4, Lordship. In this letter, Lordship, I have categorically made a stand, Lordship, which is mentioned that, sir, the above rake containing 42 wagons of bitumen was placed in two parts, starting at 1940 hours on 14/9/2021. As per notification number dated 9/9/21, it clearly mentions that a 48-hour due notice is to be provided to the client. No such notice was received by IOC. Here, IOC is the main consignor, Lordship. We are the clearing agent, Lordship. So the petitioner is the clearing agent appointed by the IOC. The consignment is belongs to the Indian Oil Corporation, Lordship. So we are the agent. We are the clearing and forwarding agent appointed by them, Lordship. So as we were not informed of the change, this circular does not apply to us. So we have categorically made a stand that since you have not issued a 48-hour notice, advance notice, so we are not entitled to pay any damage. And, Lordship, another grievance we have made a stand, Lordship. As per the circular by the Indian Railway guidelines regarding round-the-clock working at railway terminals, it mentions the following points. First, approach road. We have attached image of the approach road area of unloading yard. There were places where trucks could not be placed next to the wagons. Also, as there are large holes and loose soils, the trucks get stuck in the yard due to loose soil and with ditches in it. So my intention is, Lordship, first, they have not issued 48-hour advance notice. Second, Lordship, the goods shed where the consignment has arrived, Lordship, that goods shed was not as per the...
After the...
Lordship?
after the damage were issued to you.
Lordship, I didn't understand what.
Your representation is after the
Yes.
office, the
Lordship, after issuance of the representation, Lordship,
Yes.
they have again issued another letter, Lordship, that is 2211. Sorry.
So these are after demand notice.
Yes.
Yes, Lordship. So page
But
27.
you are admitting that it was not unloaded.
Yes.
Yes, Lordship. Because of these reasons, Lordship, Corona and Lordship, everything, Lordship, we have admitted that we are not entitled to pay any panel damage charge. But the thing is, Lordship, we have also agreed that normal damage charge we can pay, Lordship.
That is admitted, my lord.
That we have admitted and we are ready to pay
Not the
because
damage.
normal damage, which will be calculated at the rate of rupees 150 per wagon. So since there are total 42 wagons, Lordship, so 150 multiplied by 42, the result which is we are ready to pay, Lordship. We have no objection on that. But Lordship, the issue that is precondition which is required to be fulfilled, that is very mandatory, Lordship. And I would like to produce one judgment of this Honorable Court, Lordship, which is passed in WPC number 2607 of 2012 in the case of Arki Coals and others versus Union of India and others. In this case also, Lordship, similar issue was raised, Lordship, and the Honorable Court at paragraph 11 and 12, Lordship, have observed some, made an observations, Lordship. May kindly see that paragraph 11 and 12. Lordship, may I read paragraph 11?
Yes.
Consider the submission of the learned counsel for the parties. The respondent, Senior Divisional Commercial Manager, Northern Railways, Ambala Cantonment, filed the affidavit in opposition on behalf of the respondents. It is stated in the said affidavit in opposition that the panel damage was imposed as per rules and the placement of rakes were made by operation of feasibility and availability of space. The Railway Board Rate Circular number 74 of 2005 authorizes CCM, COIM and DRM to impose panel damage after giving 48 hours advance notice to the parties, and the said increase in the damage rate is subject to maximum of 6 times of the prevalent rate. Mr. Das produced the corrigendum number 2 to rate circular number such and such, whereby under group 1 wharfage rates would be levied under group 1 rupees 100 per wagon each or part thereof, and the said rate is applicable uniformly for all types of wagon with effect from 1 to 2008. The stand of the railway is clear and specific that the panel damage charges are to be imposed after giving 48 hours advance notice to the parties. On perusal of the wagon transfer register produced by Mr. Das, the learned counsel for the railways, it is seen that the rack of the present petitioner was placed for unloading on 6/4/2012 at 9:30 hours. From the said register itself, it is clear and apparent that the said panel damage notification was issued on 7/4/12 at 17:45 hours. From the annexure 4, which is the copy of the said notification of panel damage, it is seen that the same was received by the agent of the petitioner on 7/4/12 at 18:15 hours. There is no evidence brought by the respondent railways in order to show that the said panel damage was imposed after giving 48 hours advance notice to the parties. Clause 3.3 of the rate circular number 74/2005 dated 19/12/2005. This should be, Lordship, 19/5/2016. There is a typographical error. 19/5/2016, Lordship. Speaks of
16.
Yes.
Which you are relying. Which
Yes,
you have
Lordship.
relied.
Yes, Lordship.
Yes.
So clauses 3.3 of the rate circular number 74/2005 dated 19/12/2005 speaks of in case excessive congestion takes place at any terminal, CCM, COM, DRM can increase the damage rates even at progressively increasing rate subject to a maximum of 6 times of the prevalent rate. This panel damage rate should be implemented only after giving wide publicity and due notice of 48 hours and should be applicable for the notified period. So here, Lordship, my case is similar, Lordship. In my case also, they have not issued any wide publicity, nor they have given any, Lordship, 48-hour advance notice. So, Lordship, since, Lordship, this panel damage charge is against the guidelines of the Railway Board, So, my lord, my humble submission would be, lordship, kindly this their levy of panel damage charge shall be set aside, and lordship, we are not entitled to pay any panel damage charge. If lordship permit, then I can make a fair submission that there were a delay, lordship. There was a delay, lordship, no doubt. But we are already admitted in our affidavit that yes, so we will going to pay that normal damage charge. If lordship pleases, then lordship can order that part, lordship. But lordship, panel damage charge we are not going to pay because it is in violation of the railway board circular. Second thing is, lordship, the corona period. It is very crucial to note that, lordship, because at that point of time, lordship, laborers were not available. So we are nowhere, lordship, responsible, or we are liable, or lordship, we did anything bad thing that, lordship, we intentionally we did not do anything that, lordship, may cause the railway to suffer loss, lordship. So it is our humble submission that, lordship, since during the period of corona, lordship, this entire consignment was unloaded, lordship. So their levy is not justifiable, lordship. This is my humble submission. Second thing, lordship, here there are number of orders in this case, lordship, where the Honorable Court directed the railways to produce 48-hour due notice, lordship. But till date, lordship, they have not produced any notice. They have made a stand, lordship, that they have pasted one circular at the goods shed, lordship. So we are saying that we have not received that notice also, that particular circular, lordship. So our submission is, lordship, since this is in terms of the judgment laid down by the Honorable Judge Prasanta Kumar Deka in the case of R.K. Coles, and lordship, another judgment I would like to praise. This is in the court of Delhi, which was decided in the court of Delhi, lordship. Another case, similar grounds were taken, lordship. Para 13 is very relevant. Here also, the Honorable High Court, Delhi High Court, have made an observation that 48-hour due notice is important, is relevant, and wide publicity is also important before implementation of panel damage charge. So these two judgments were very much relevant, lordship. Para 13. Para 13, in the case of Union of India and others versus Haryana Power Generation Corporation Limited. Similar issue, lordship, panel damage charge, and here in paragraph 13, it was observed that the appellants have submitted.
Give the fair copy. This is something upside down.
Upside down.
Not upside down. Some pages are missing.
Lordship, pagination is correct, lordship, but the serial number is wrongly typed, lordship. Here, after paragraph 50, again paragraph 9, they have written, lordship. This is the mistake done by them, lordship.
So how do you get it?
The publisher, she wants to say.
Yes, lordship. Pages are correct, lordship. There are total 6 pages, and all 6 pages are there, but
if it was an SCC version, the pagination and the paragraph numbers would have been in Sariyat and Manupatra.
It's a Manupatra.
Get the better one.
Lordship, if permit, I will place it.
Anyway,
even though, lordship, the Honorable Guwahati High Court has also made a similar observation that 48-hour due notice is mandatory and wide publicity is also mandatory. SCC. SCC Pabul.
Give the SCC level.
Delhi High Court, na?
Delhi High Court.
May not be.
Though, Lordship, we are not bound by the decision of the Honorable High Court Delhi, but Lordship, similar ratio may be also.
Which paragraph you are referring?
Paragraph 13.
Yes.
Okay. The appellants have submitted that in the present case there were long delays in release of rates, and this was duly intimated and recorded in the register maintained by the respondent at the railway siding. This aspect has been dealt with in the award and the contention was rejected. The requirement as per circular dated 22/23/10/2008 was issued of 48 hours notice. There is no evidence or material on record to suggest that this notice were ever given or served. The requirement of judicious valuation whether or not panel damage charge should be charged and at what rates was violated. There was no evidence or material to show that panel damage charges had been levied keeping in mind the aforesaid mandate and requirement. And accordingly, Lordship, after hearing everything, Lordship, this writ petition filed by the Union of India was dismissed, Lordship. So the contention is, Lordship, this 48-hour due notice is required, Lordship, as per paragraph 13. So, Lordship, the first representation that we have filed, Lordship, before the railway administration, that representation was never refuted by them, Lordship. Earlier, they have charged us rupees 7,14,420.
You said, okay.
Lordship?
Yes, next.
Lordship, in our representation, that is 16/9/2021, in that representation, Lordship, we have categorically made a stand that 48-hour notice is required, and they
After
have
the
not.
demand notice.
Yes, Lordship, and in that representation, we have also made the stand that this charge they have charged 7,14,420, which was later revised to 5,15,970, Lordship. Again, they have revised by their letter dated 22/11/2021, and they gave us, Lordship, 30% waived. The amount was again waived to 30%, Lordship. But the entire episode revolves around the two conditions, that whether they have fulfilled the condition or not. Just now, Lordship, the counsel for the respondent made a stand that we have a right to file the case before the learned RCT. But here the question is, Lordship, whether this issue, this legal issue, Lordship, the panel damage charge, levy of panel damage charge is maintainable or not, that power was not vested upon the Railway Claims Tribunal. The Railway Claims Tribunal has the power to refund, to grant compensation, Lordship. But
Is it the demand notice appealable?
Lordship?
Appealable. Is it appealable?
It is appealable, but first, Lordship, whether they have complied the condition or not, that is
No,
very
it's
much.
okay. If it is not applied, I mean, if it is not,
Their charge, their demand is also illegal, Lordship. First, you have to fulfill the condition. If you have fulfilled,
no,
then
if the demand is appealable,
this
yes,
order, no,
the
Lordship.
appellate court can very well look into
No,
this
Lordship.
aspect.
Here the prescribed guideline is first you have to fulfill the condition. Second thing is, Lordship, they have given us the power to write a representation before the competent authority. They will, after scrutiny of everything, Lordship, they will grant us the waiver, Lordship, that they have done on 22/11/2021. They have given us 30% waive, Lordship. But Lordship, again they are saying that we have to approach appellate forum for another lordship revision of this amount, lordship.
No, if the-
But my contention is I am not entitled to pay panel damage charge, lordship, because they have not fulfilled the conditions. And
What is the
lordship,
jurisdiction of appellate authority?
lordship, since there is a writ petition, already one direction was given, lordship, in the same writ petition, lordship. This writ petition was already entertained in the case of Archie calls, lordship. Here, the honorable court clearly made a observation that, lordship, 48-hour notice is required, lordship. If
The issue of maintainability regarding appeal
Yes.
was not availability of the alternative remedy was not chambers.
Lordship, the Railway Claims Tribunal have the power to grant compensation and refund, lordship. But the issue of panel damage charge, whether it is justified or not, that power was not given to the tribunal. Lordship may kindly, yes, lordship.
So that's what I'm saying. If the demand notice is appealable, you are agreed by the demand notice.
No, that demand notice, we cannot challenge that demand notice before the Railway Claims Tribunal.
That's what I'm saying. That's what I'm saying. Is it appealable or
No,
not?
no, no, lordship. No,
If
lordship.
it is not appealable, obviously it will.
They have filed several original applications before the RCT, the same chamber, my lord. I can give the case numbers, my lord. It is called original
Lordship,
applications.
let's stick to this case.
Now she says that stick to this case.
Because we are not in this case, lordship. We are
The
in this
same
case.
chamber, my lord. Number of
the demand notice which you are agreed
Yes.
is it an appealable
No, lordship. No.
notice?
There is
If
no
the
such
notice-
provision in the
if the
Railways Act.
notice is appealable.
Lordship, there is no such provision in the Railways Act, lordship.
They don't call it an appeal, they call it an original application. The jurisdiction to challenge railways action lies with the RCT.
Including
my submission is
including the demand notice.
Demand notice. And
Lordship, may
second,
kindly see section
Let her complete,
16,
my lord,
13 and 16, lordship.
section
13 of the Railway Claims Tribunal Act 1987. Lordship will get the idea whether the Railway Claims Tribunal have the power to set aside the demand issued by the respondent authorities, lordship. 1987 Railway Claims Tribunal Act.
I can hand over my copy. I can-
You did that electricity tax also. No, you keep it there. Yes.
Section 13, lordship. What are the powers vested upon the Railway Claims Tribunal, lordship? 22. Yes, Uma.
Yes.
Lordship. Now, lordship, kindly come to section 16, lordship. What kind of claims we can make before the claims tribunal? Applications to claims tribunal, lordship.
Yes.
Here, lordship, nowhere it is mentioned that we can challenge that demand notice before the railway claims tribunal. What we can do, lordship, we can file a claim application for compensation if lordship goods were lost, damaged, deteriorated or non-delivery. Then lordship, we can file a claim application before the railway claims tribunal to get the compensation. Second thing is, lordship, if suppose lordship the railway charge some extra freight, lordship, which is not legal in terms of the law, then we can file claim application for the refund of that excess amount, Lordship. So, Lordship, by virtue of section 13 and 16, Lordship, we have the power, we have the right to file a claim application to claim for compensation on account of loss, damage, deterioration, if the goods were lost during the transit period, Lordship. Second thing, Lordship, if they have charged extra freight, Lordship, then we can claim for the refund, Lordship. But, Lordship, the question for challenging the demand notice, that was not given under section 16 and 13, Lordship. Lordship,
According to you.
according to me, Lordship. And here, Lordship, the prescribed guidelines issued by the Railway Board, Lordship. First chapter is, Lordship, chapter 1, which is, Lordship, 19/5/2016. Chapter 1 is very clear, Lordship. First, you have to follow these guidelines regarding damage and stabling. So, under this guideline, para 3.4 comes, Lordship, and 3.4 says, first, you fulfill these two conditions. After that, Lordship, another part is that we can raise this matter to the appellate forum, Lordship. That will come later. First, you fulfill the conditions, Lordship. If they did not fulfill the conditions, how am I supposed to pay this panel damage charge, Lordship? I am also agreed with this their part, Lordship, since there is a delay on my part to unload the consignment. So my fair submission is, Lordship, I am ready to pay the normal damage charge, which will be calculated at the rate of rupees 150 per wagon, Lordship, which will come around 1,14,000 something, Lordship. So, Lordship, if Lordship permits, then I can pay that amount, normal damage charge. But, Lordship, this panel damage charge will be calculated 6 times of the normal damage charge, which is very much.
He has to accept that. Do you agree?
No, definitely not.
Then, Lordship, you can see the guidelines, Lordship, and the judgment of this Honorable Court. It is very clear, Lordship.
Yeah, I haven't understood. According to you, admittedly, the was not unloaded during the free time, which you are supposed to do because of the COVID.
COVID, Lordship.
Number two, be that as it may, the circular requests that before charging
Panel damage charge.
you will have to be issued 48 hours.
You show notice, focus notice, yes, Lordship. And wide publicity is also important, Lordship. Yes, Lordship. So this is my submission,
So
Lordship.
admittedly, that has not been done.
That has not been done.
Therefore, this is bad.
So,
But what is the result then?
Lordship, this will set a
The
precedent,
facts you are
Lordship.
admitting.
Yes, Lordship.
You are only on the form that requirement of notice has not been given.
Correct, Lordship.
Suppose if the notice was given, what you would have done?
We will accommodate the arrangement, Lordship. We will accommodate the laborers if they have given us the notice prior to the
When the lockdown was there, partial lockdown.
partial lockdown is there, Lordship.
restriction,
But
then even if 48 hours was given, how would you manage?
Lordship, we will try our best because at least opportunity must be given, Lordship. Principle of natural justice must be followed, Lordship. And the rules specifically says that you have to give 48-hour notice, Lordship.
Principle of natural justice cannot be applied in all and sundry.
Correct, Lordship. But Lordship, during the pandemic period, second wave of
That's what I'm
corona.
asking.
Yes,
Had you
Lordship.
been issued a 48 hours notice, you yourself has said, because during pandemic, no labors, nothing, therefore you could not unload it.
Correct.
So even the 48 hours notice was given, how would you have managed it? You would
But
not
at
have managed
present,
it.
Lordship, in number of cases, Lordship, I made a fair submission, Lordship, here. Since our chamber deals with these railway matters and number of claim applications, number of appeals were pending before this Honorable Court also, Lordship. Similar ground was taken by us, Lordship. And in all the cases, railway did not produce any 48-hour notice, Lordship.
No, it's okay.
So this will
I'm
set a
asking,
precedent,
have
Lordship.
you-
If
have-
Lordship,
No, had you been given a 48 hours notice, what would you have done?
Lordship, we will
Yes,
try to
because
accommodate and
you could
try
not
to
have
arrange
done
the labours.
anything except for saying that you could have tried.
But Lordship,
but
at
but
least,
when you are
Lordship-
saying that it was during the lockdown and restriction was there, no labor, nothing.
There was no restrictions.
I have given the options, Lordship. Lordship, if permit me, Lordship, these rules are very clear, Lordship. I am bound by this rule, Lordship, and the Honorable High Court also made a similar observation, Lordship. If Lordship please, then Lordship will decide it on merit, Lordship, based on these two judgments of this Honorable Court. One is with from this Honorable Court and the other is Delhi High Court, Lordship.
Because the issuance of notice for 48 hours
Yes,
should have some meaning.
Lordship.
Issuance of notice should carry some logic. Why the 48 hours notice has to be issued? That's why I'm asking, if you would have been given 48 hours, what would you have done?
Lordship, first
Because
thing
you are
is,
saying
Lordship,
that because of the lockdown or partial lockdown or restriction, you could not have cleared the wagons.
correct, Lordship. But here, in this case, Lordship, they have purposely unloaded the consignment at Lordship 1940 hours. That is, Lordship, 7:40 p.m. in the evening. So during that period, Lordship, evening time, Lordship, it is,
Knowingly.
yes, Lordship. Lordship, because Lordship,
How can
the
you say
rules
that?
are there, Lordship.
Railway is not.
If Lordship,
it's not-
they have unloaded the consignment after 6 p.m.
Is there
Lordship.
any enmity between you and the railway?
Lordship, may I submit one point, Lordship, if Lordship
Yes.
permits me? There is a rule, Lordship, if the consignment unloaded after 6 p.m. Lordship, then round the clock working will be given to the party, Lordship.
Yes.
Round the clock working, Lordship, will be given by them to us so that we can, no, let me say. So then we will accommodate the things, Lordship. That is my thing, Lordship. If they have not given us the notice prior to Lordship levy of this damage, Lordship, we can do it our best to accommodate and arrange the labels, Lordship. And round the clock working was not there, Lordship, was not given.
Then in that case, don't rely on the lockdown, COVID-19.
But Lordship, the fact is, at that point of time,
The moment you said you could not do it because of the lockdown, restriction, no labor, nothing.
since
then
that
48
prayer
hours
was
of
there,
the 48
Lordship, in
hours
my
notice
representation.
would be unnecessary.
Correct, Lordship. Lordship is correct, Lordship. But since there is a prayer also, Lordship, so it is my duty to address those facts also. But Lordship, the primary issue is that, Lordship, before implementation of penal damage charge, Lordship, these two conditions needs to be fulfilled, Lordship.
Yes.
That is my humble submission, Lordship. Our second question is, Lordship, that we have not annexed that company board of resolution, Lordship. But Lordship, later we have annexed that document in my affidavit in reply, Lordship, that company board resolution, annexure 1, Lordship. But Lordship, here the petitioner is already authorized by the company Indian Oil Corporation, and that authorization letter and work order was already annexed in my writ petition. So Lordship, again, question of filing the memorandum of association, board of resolution is not arise, Lordship, at this point of time. But since the Railway Council have made a stand that we have not filed that company board of resolution, this writ petition is not maintainable. So in my submission, Lordship, I have already filed that board of resolution in my affidavit in reply.
Not filed, also.
Affidavit in reply, page 189.
Probably she has not understood my submission, my lord. She has annexed the memorandum of association of the company. I am not on that, my lord. There has to be a resolution by the board of directors authorizing the person concerned.
That was already there in my writ petition.
If it's there, I'll not object to it.
I have annexed it.
Where is that? If it's there, I'll withdraw my submission. It is there.
Okay, let me sign for this. Since the petitioner is a director, one of the director, Lordship, he has full power to file this writ petition.
It's not there, my lord. I'm absolutely sure.
Lordship, page 36, annexure 9. Here the petitioner is Mukesh Jalan, who is impleaded as petitioner number 2, and the author, page 36. These are very technical issues raised by him, Lordship. Since the Mukesh Jalan is the petitioner number 2 and he was appointed by the Indian Oil Company, our consignment, that is bitumen, was held up by them since 2021, Lordship. And Lordship, nowhere they have denied in their letter, Lordship, impugned letter dated 22/11/2021, that we are not entitled to file this claim, Lordship. Mukesh Jalan is a petitioner number 2, Lordship. He was appointed by Indian Oil Corporation in terms of letter dated 1st September 2020. I have annexed this document authority letter, Lordship, at page 36 of my writ petition. Here, Lordship, Mukesh Jalan was appointed to act as carrying and forwarding agent on behalf of the petitioner number 1, that is Messrs. Sadguru Engineers and Private Limited, Lordship. So, since Mukesh Jalan was acted on behalf of the petitioner number 1, Lordship, he has the power to file this writ petition, Lordship. If Lordship permits, then so far as company board of resolution is required, Lordship. This is very technical issue, Lordship. If Lordship permit, then permit a next date, Lordship, I will produce that company board of resolution, Lordship. But because of that part, Lordship, my grievance should not be, Lordship, withheld, Lordship, should not be discarded, Lordship, because of that technical reason. The primary issue is whether they have fulfilled the condition or not.
Yes.
My lord, first things first, my lord. Lordship may kindly take up the affidavit in opposition filed by me. Therein I have taken the preliminary objections, 3 preliminary objections, my lord. If I may bring to your Lordship's notice those objections, my lord. Lordship may kindly take up the affidavit in opposition filed by me, my lord. Page 108, my lord. Page 108. I'll not take much time, my lord.
Next week. We'll keep it part of next week.
Next week.
In the meantime, Lordship, please, Lordship, permit me to produce that company board of resolution.
Whether would it be
At
acceptable
the
or not.
hearing stage, that thing
No,
cannot
because
be
he
rectified.
raised that issue, Lordship, because
Ask Mr.
M. Sharma.
M. Sharma, learned counsel for the petitioner, and also heard Mr.
B. Sharma.
B. Sharma. Mr. Matter after week is part of.
No, I have serious objections to that, my lord. At the hearing stage, there necessary.
Whatever is
Lordship, if possible, a date may be fixed, Lordship.
next week, 13th.
Next
13th is
13th.
13th is Friday, Lordship. It's motion day, Lordship. If possible, can it be on 12th of
12 to have so many cases.
12th. I'm also
Lordship?
preoccupied.
17th, if possible. 17th,
Let it be on 19th, my lord.
19th, then
19th.
no part heard. 19th I'll not be there. This court will not.
All right.
17th,
13th will be 13 will be convenient, my lord. 13th.
13th. We'll see on 13th. 13th last day for this session.
Well,
Then we'll
Wait on another.
get it spill over.
Lordship would be
After
leaving.
17th of January.
Probably Lordship is
We'll
staying.
make it after 17th January.
Yes, no problem.
Lordship,
The stage is in your favor.
No,
The stage operating in your favor.
Lordship, it is
There is
now
no stay order, but we have not taken any.
Yes, there
course
is a
of-
direction not to take.
But it was not continued.
It was not continued,
Continued.
Lordship, because
After 17th January. Then in that case. Because
17th of January, Lordship.
I have so many important matters next week.
17th of January, Lordship.
After 17th. 21 January.
21 January. Lordship, if possible. Lordship,
21 January. Part heard, huh? Part heard?
Well,
just hear your this, maintainability and on merit. That's all. Have I
Even otherwise, my lord, just to point it out to your lordships, same issue between the same parties has been decided by this honorable court. I'll place that, my lord. Same issue between the same parties, my lord.
Lordship, that
Same
was
party.
on different ground, Lordship.
No,
Again,
no,
he is
absolutely no.
mixing
We'll
up
see,
the
we'll
cases.
Well,
Obliged.